Hi, everyone. I'm meteorologist Matt Scott from the Fox 61 Morning News. I'll give you all a moment to let the virtual applause die down. Okay, welcome to the 2022 Virtual Administrative Assistant and School Secretary Conference, sponsored by the Connecticut Association of Schools. I'm glad you're joining me this morning. As you can imagine, we would all rather be attending this conference together in person instead of this box. To recognize and thank our administrative assistants and school secretaries for everything you do to keep our schools running smoothly and support high-quality education across Connecticut. However, even though the number of COVID cases are declining now across the state, that wasn't the case back in late January when we made the decision to go virtual this year. But there is cause for hope and optimism as we begin to adjust and transform our way of life into what will become the new normal. And being here together this morning through our shared internet connection is how we show our resilience and our adaptability in the face of this pandemic. So let's focus on what's important and why we're all here to thank all of our hardworking, dedicated, and truly amazing administrative assistants and school secretaries for everything you do each day for our administrators, our school faculty and staff, and most importantly, our students and our families. Our Connecticut schools would not be the high quality and high performing schools they are without the difference you make through your dedication each and every school day. So even though Wednesday, April 27th was Administrative Professionals Day, we want to celebrate and recognize each of you today and shine the spotlight on you this morning. We have a really exciting program for you. We begin this morning with a presentation by attorneys Thomas Mooney and Gwen Zittoun from Shipman and Goodwin. Shipman and Goodwin, excuse me. Well, even in Zoom I mess things up. Who will discuss how the current legal landscape in schools has changed due to the pandemic and how state and federal laws in relation to education affect school districts and the work of administrative assistants. Following their presentation, you'll have the opportunity to ask Tom and Gwen questions during the Q&A, like, couldn't we get somebody better than Matt Scott? We're also looking forward to a presentation later this morning by motivational speaker Kate Garnes, who will help all of us find moments in the madness. And we will be recognizing the recipient of the CAS 2022 Administrative Assistant of the Year Award recipients, along with a special tribute to all of our administrative assistants and school secretaries. So let's get started. It's my pleasure to welcome CAS Assistant Executive Director, Dr. Rosie Wojtek, who is going to kick off this morning's exciting program. Take it away.
Thank you, Matt, and a great welcome and introduction for our virtual assistant, administrative assistant, and school secretary conference. We greatly appreciate having you open our conference and help us recognize, thank, and shine a spotlight on our amazing administrative professionals. So thank you again, Matt and Fox 61 for joining us this morning. Again, my name is Rosie O'Brien Wojtek, and I'm the Assistant Executive Director of the Connecticut Association of Schools. On behalf of all of us at CAS, it's my pleasure to welcome our administrative assistants and school secretaries to our virtual conference. As Matt said, we were really looking forward to having this conference in person at the AquaTurf this year, but in late January, with COVID cases on the rise, we had to make a difficult decision to go virtual. But no worries, because as Matt just outlined for you, we have some exciting presentations and a few surprises along the way. So sit back, relax, and get ready for a very informative, invigorating, and inspiring morning together. We have missed you the past 2 years when we couldn't hold this conference at the AquaTurf due to COVID. So even though we can't see or hear you, it's great to know that we're able to be together virtually to recognize and thank each and every one of you for the amazing work that you do. One of our biggest supporters over the years for many of our CAS events, including this Administrative Assistant and School Secretary Conference, is Fox 61. Again, I would like to thank Matt Scott and the entire Fox 61 News team for being here this morning and for their support of CAS-CIAC, especially for our schools, our students, and this morning, you, our administrative assistants and school secretaries.
You can always expect more on Fox 61 News. And now you can stream it right to your home, on demand whenever you need it. Fox 61 News on Roku and Amazon Fire TV. Search Fox 61 and download the app today.
And in addition to Fox 61, we would also like to gratefully acknowledge our wonderful corporate partners Pullman and Cumley, Connecticut Army National Guard, Connecticut Department of Public Health, Connecticut Alliance to End Sexual Violence, Connecticut Department of Transportation, Connecticut Lighting, Jostens, MCM Fundraising, and Horseman for helping to make this conference possible. In fact, right now we have a brief message from one of our sponsors, Horseman, to share with you.
Hi, we're Horseman, and our passion for educators goes way beyond insurance. We're also here to help tackle challenges like student loan debt. More than 60% of educators have student loans hanging over their heads, which weighs heavily on their decision to stay in the classroom. In fact, 34% are considering leaving due to financial stress. We know some of your team might be in the same boat, but we also know they don't have to be. 70% of the same educators would stay if they could just get a lower student loan payment, which is why we created our Student Loan Solutions program. It offers an online suite of tools and loan coaches to help educators manage their student loan debt and apply for federal loan forgiveness. Our program has helped educators find more than $350 million in student loan forgiveness. And the best part is that we've made it complimentary to educators. Let us help you retain the talent you worked so hard to acquire. Continue the conversation with your local agent or learn more at horseman.com.
Again, we want to gratefully acknowledge and thank Horseman and all of our other corporate partners for their continuing support of our professional learning opportunities for administrators and educators in Connecticut. On behalf of all of us at CAS, we're excited to welcome you to the 2022 Virtual Administrative Assistant and School Secretary Conference, and very glad you're joining us. Before we begin, we have just a couple of reminders and housekeeping items. First, we will be using a webinar format. Due to our large number of participants, your cameras have been turned off and you will be muted. We will be recording this entire conference and posting it on the CAS website. Everyone who registered for this conference will receive an email when the recording is available for viewing. Please share the video from this conference with your colleagues and friends. Also use the Q&A for any questions you might have during the conference, especially during our first presentation, as it will be followed by a Q&A with our presenters. We have a full agenda, but we will do our best to answer as many of your questions as we can. If you have technical issues, please use the chat as we will be monitoring it. In addition, the chat will remain open so that you can add your comments and thoughts during the conference. Some of you have asked if we will be providing attendance certificates to those of you who attend today's virtual conference. If you need a certificate, please email Kathy Pro at cprowe@cas-ciac.org. And we will be dropping that link into the chat. There it is. And when you send us the email, we will send you a certificate of participation. Again, you need to let us know via email if you want a certificate of participation. We hope that you will share this recording from the conference with your colleagues and friends, view it at your leisure, and use it as a professional learning tool for yourself and those you work with in your school communities. Please join me in recognizing and thanking our CAS Administrative Assistant Conference Planning Committee for the hard work that they've done behind the scenes to bring this conference to you. And we will also be dropping the link to our brief evaluation survey into the chat and posting it on the screen several times during the conference. We greatly appreciate your feedback and thank you in advance for completing the survey before you leave the conference today. It's now my pleasure to introduce my colleague and friend, Dr. Bill Silva, Associate Executive Director of CAS, who will introduce our speakers for our first morning session. Welcome, Bill.
Good morning. Thank you, Rosie, for that introduction. And good morning, everyone. We're really happy that you were here. I'm Bill Silva, Associate Executive Director at the Connecticut Association of Schools, and I'll be moderating our first conference session this morning, featuring our distinguished attorneys, Thomas Mooney and Gwen Zittoun from the law firm of Shipman Goodwin. Before I introduce Tom and Gwen, let me remind you that during the presentation, you in the audience are muted, but you're able to ask questions using the Q&A feature on your screen. And so please drop in your questions during the presentation. And we have a question and answer period after the presentation, and Tom and Gwen will answer as many questions as they can during that half-hour period. So let me now introduce our presenters. First, attorney Gwen Zittoun is a partner at Shipman Goodwin and a member of the firm's School Law Practice Group, representing boards of education and public school districts in the areas of student data privacy and confidentiality, contracts and board policies, Title IX compliance, special education, and general education matters. Gwen is the key drafter of Shipman's model policies on topics ranging from bullying prevention to school district budgets, and she has helped prepare Connecticut school districts to handle new developments in the law, such as COVID-19. A graduate of Emory University and Albany Law School, Gwen has served as an adjunct professor at the University of Connecticut's NEAG School of Education. And attorney Tom Mooney is a partner at Shipman Goodwin, and he's the author of A Practical Guide to Connecticut School Law, now in its 9th edition. In addition to his extensive practice in all areas of school law, Tom teaches at the University of Connecticut School of Law, serves as professor in residence at the NEAG School of Education at the University of Connecticut, and is adjunct professor in both the School of Law and the School of Education at Quinnipiac University. A graduate of Yale College and Harvard Law School, Tom has been widely recognized for his many notable contributions to the law and to education in Connecticut. Welcome, Tom and Gwen. So pleased to have you. You're good friends to CAS and good friends to us. And I know we have an exciting morning ahead of us with your presentation. So thank you for being here to share your knowledge and experience with us and our audience. And I turn the presentation over to you.
Great. Well, good morning, everybody. It's good to be here. And it's time flies. I think Gwen and I have done this presentation for over 10 years. And we missed you last year and the year before. And I hope you missed us. But we're here to provide to you some updates on legal developments. And perhaps most importantly, to give you an opportunity for some free legal advice. So we hope that you take advantage of the opportunity to ask questions, and we'll spend some time with you now with that update. Gwen is going to start this off with an update on Title IX, which is quite complicated, and I hope someday to understand it half as well as Gwen does. And then I'll be providing an update on some recent legislative changes, and Gwen will follow up with further updates on legislative changes. So with that, I'll turn it over to Gwen. And again, welcome all of you. Thank you.
Thank you, Tom. I'm going to assume, Tom, that you can see the slides up here because it's hard for me to make sure. Perfect. Excellent. Well, it's so nice to be here with everyone. And I just want to echo Tom's comments that we wish we could have been in person, and we've missed you for the past 2 years. I'm sure there's some familiar faces out there, although I certainly wish we could see you. I'm seeing the numbers of participants, and it's just really nice to see that so many people are joining us this morning. Here's the very brief outline. I know Tom already went through this. It looks brief, but we haven't seen you in 2 years. So a lot has happened, and especially considering all the changes relative to COVID-19. We've certainly had a ton of state law changes. We've also had some federal law changes. So we're going to start off by talking about Title IX. And Tom was very kind to say that I know everything about Title IX. I'm not so sure anyone at this point can know everything about Title IX, but we're all doing our best because we've had some pretty significant changes over the last 2 years. Not only with our COVID-19, remote instruction, all sorts of things, but we've had federal law changes as well. It's actually quite timely that we're talking about this now, because in just 2 months, we are going to reach the 50th anniversary of Title IX. You might have seen some news about it. There are some really museum displays in New York. At the New York Historical Society is doing a whole display on Title 19 and the history, Title IX, sorry, and the history of Title IX. And it's a monumental time really for this law. So just a little bit of history, because I always find this piece interesting, that first of all, this is the language of Title IX, 37 words. And that's it. This is the statute. And it was enacted back in 1972, many years, well, almost 10 years, right? 8 years or so after a significant civil rights laws were passed. And those civil rights laws dealt with equality in employment, related to a variety of protected classes, race, national origin, ancestry, and sex, but as related to employment and some other areas of public accommodation, but didn't address education. And so fast forward to 1972, and there was this attempt, quite successfully, to essentially pass the same law relative to educational institutions. We know Title IX very commonly to deal with athletics. That is very common understanding of Title IX, that it says that if you have athletics for men, you have to have athletics for women. That's a very broad statement. It's quite more specific than that. However, this is the language of the law, and you will see that it says nothing about athletics at all. In fact, it mirrors almost identically the language of other civil rights laws relative to a prohibition against discrimination. So Title IX is a civil rights law. It says that no person in the United States shall, on the basis of sex, be excluded from participation in, denied the benefits of, or be subjected to discrimination under an education program or activity receiving federal financial assistance. A lot of words, a long sentence, but essentially what it means is if you receive federal funding as an educational institution, you may not discriminate on the basis of sex. That's broken down very, very basically. So where did we get the piece about that athletics? Where did this come in? It had always really was very fascinating to me as to why that happened, given the language being very broad. And if you look into the history of it, it was essentially because there was an amendment proposed a few years after the law was passed to exclude athletics from Title IX, meaning that there's going to be an exemption that says athletics doesn't have to comply with this rule against discrimination. Now, that did not pass. As we now know, 50 years later or so, that this law applies equally to the provision of athletics as it does to just the provision of education on the basis of sex. But it kind of stuck throughout history that we think of Title IX now as related to athletics. Now, very clearly we know, and as the courts have explained to us in the years following the passage of Title IX requires that we provide equal education to all individuals, and we can't discriminate on the basis of sex. So that is access to colleges and universities, access to courses. And through the years, it has also developed to be made clear that sexual harassment can be a form of discrimination, in that if individuals are being harassed on the basis of sex in an educational institution, they are essentially prevented from accessing their education, and thus they are being discriminated against. So we see sexual harassment as kind of a larger, sex discrimination, the language of Title IX, as a big umbrella. It's a pretty broad definition, but sexual harassment is a piece of that, in that when you are engaging in conduct that meets a very, very strict definition under Title IX of sexual harassment, then you have prevented an individual from accessing their education. Now, you also, importantly, the language of Title IX, as you see here on your screen, doesn't say protecting men, doesn't say protecting women, doesn't say anything like that. It just says on the basis of sex. And so through the years, over these 50 years, we've seen a lot of developments in the law as to what that means. We're going to talk a little bit about that today. That was your mini history lesson for the day. So how does Title IX get enforced? Importantly, Title IX is a federal law. We're going to talk in a minute about some other laws that might apply as well relative to discrimination on the basis of sex, but we're going to talk really specifically about federal law. So Title IX is enforced in two broad ways. One is essentially administratively, and that's where you see here OCR, that's the Office for Civil Rights, and the other is through the courts. And those are very broad categories. The Office for Civil Rights is an arm of the United States Department of Education, and their job is to enforce civil rights laws in educational institutions. So they're charged with enforcing laws like the other civil rights laws that protect against discrimination based on the basis of race, on the basis of national origin and ancestry, on the basis of religion. They are also charged with enforcing Section 504 of the Rehabilitation Act, which might be a familiar term that protects individuals against discrimination on the basis of disability. They are also charged with enforcing Title IX from an administrative perspective. So what happens when OCR receives a concern? They could receive a complaint from a parent, from a community member, from an educational institution sometimes, or individuals within that institution or other institutions. They receive a complaint and sometimes they decide that they're going to investigate and look into it. And some of you might be familiar with this. And from the perspective of your role as administrative assistants and secretaries in the schools, you might have been asked to collect a whole lot of information, because that's what happens when OCR comes in. They might be investigating one complaint, but they're probably going to ask you to open up all of your proverbial files, electronic and physical, and provide them with a ton of information. This can be quite time consuming. Pre-COVID, at least, they would often come into the schools, interview individuals, want to talk to people, want to look at your records, want to look at your policies, your procedures. Eventually, what happens is usually OCR will come to a resolution with a school district if they believe that there may have been a violation. Their standards are a bit lower than, for example, in the courts, meaning it's kind of a broader perspective that they take, right? They want to make sure that we're following the letter of the law, that we're following the procedures, and that remedies are available to any individual who may have been discriminated against or treated inappropriately relative to these federal laws. Their ultimate authority at the very end of these processes is to withhold federal funding. That's a rare circumstance, although it does happen. Most often there's an agreement, a resolution agreement, where the educational institution and the individual making the complaint come to an agreement with OCR as to steps that should be taken moving forward. Often it looks like revising policies and procedures, or providing some kind of other compensatory services to parties. The other way that we see Title IX enforced is through the courts. So there's an individual right to file suit against an educational institution, and we have certainly seen this happen, both in the college and university level and in our K-12 elementary and secondary schools as well. Importantly, and I don't think that I mentioned this, Title IX only applies to entities receiving federal funding, which was the language of the statute. And that's all public institutions for sure, and some private institutions as well. So when we were talking about colleges and universities, while there are many colleges and universities that are private, they are in receipt of a good amount of federal funding, and a majority of them have to comply with Title IX. So that's where we see them kind of looped into these requirements. So individuals can file suit. We also see suits filed by the Department of Justice, which you may be familiar with, is a federal entity that can sue individuals, school districts, really organizations that have to comply with federal laws. So sometimes we do see OCR in very severe cases, turning cases over to the Department of Justice so that they can take further action. And we also see not only individuals suing, but class action. So groups of individuals claiming that they have been discriminated against on the basis of sex. So that was a very long intro to tell you why we're here today to talk about this. So not only is it the 50th anniversary of Title IX, and it is big news these days, but over the past 2 years, we have seen incredibly significant changes to how schools operate Title IX. Now, Title IX applies, as we've talked about, in a variety of areas. Access to athletics. There's a whole set of regulations that tell schools how to ensure that they're providing equality relative to athletic activities. But it also applies in all aspects of school operations or educational entity operations. And as I mentioned, one of those is relative to discrimination on the basis of sex. And that is where we're seeing these significant changes. Prior to August 2020, we had some regulations, as I mentioned, and regulations are rules that are implemented by the Department of Education, the US Department of Education, that tells us how we implement that very basic statutory language, like that first slide. So we had some rules, and the rules generally said, you have to have a process to process complaints. So you have to tell members of the school community what to do if they believe they're being discriminated against. And that process has to be equitable, and it has to be prompt, and you have to publicize your rules. There's some other language, but it was pretty basic. We learned about how to do that through guidance that was issued by the Office for Civil Rights. So we would often see what they call Dear Colleague letters explaining how to implement these regulations, what the rules should be, but that didn't have the force of law. Now that is not the case. So this is toward the end of the Trump administration. You might remember big news that one big goal of the administration and Betsy DeVos at that point was the Commissioner of Education, the Secretary of Education federally, said really we need to fix Title IX because there is this belief, and mainly it was seen at the university and college level, that individuals, mostly males, were being expelled from school, told that they had to leave on the basis of claims related to sexual harassment. And we need to implement some more due process, some more rules as to how this goes. And so that is exactly what happened. And in May, and then effective in August of 2020, we have over 2,000 pages of new rules. That included a lot of commentary by the Department of Education, and it really flipped Title IX on its head as to how we implement these rules. Excuse me. So we're right in the middle of a pandemic, August of 2020, and are told both at the college and university level and at the elementary, secondary level in our K-12 schools, these rules generally apply even-handedly with some exceptions, that we have to start over. We have to revise all of our policies and we have to implement these new rules. The new rules specifically apply to sex discrimination claims. So when an individual, whether that is a student, an employee, a member of the public, has a concern about how they are being treated relative to their gender, and they believe they've been discriminated against, whether that is on the basis of sexual harassment or otherwise, there is a new process to follow. And we felt it was really important to talk about this to you all today because you play kind of two roles in this. One, this law applies to you. It protects you against discrimination because you work for educational entities that are in receipt of federal funding. And Title IX, if you think back to the first slide about the language of the statute, it doesn't say students, it doesn't say employees, it doesn't say athletics. It just says that educational institutions cannot discriminate on the basis of sex. It's very broad, so it applies to you. On the other hand, because of these new rules, you'll see in a minute, you also have an obligation to report information that you know in the school environment up to your administrators or your supervisors if you have reason to know that sexual harassment is happening. And we're going to talk about that a little bit in depth in a minute. Most significantly, what happened here is that we used to follow guidance, and guidance from the Office for Civil Rights, it doesn't have the force of law, although it is given deference generally by the courts. The courts will say, you know what, OCR knows what they're doing. We're going to follow their rules, but it wasn't law. That is not the case now. Now this is law. We have to follow these rules. And all of our school districts over the past 2 years have been quite busy putting together their own new rules and their new policies, their new regulations, and training their staff on how to implement the new process. So I mentioned very broadly that all this stuff is new, and I'm going to highlight a couple things that are very important for you all in your positions to know, and for our school districts in general to be able to understand how to implement these new rules. The first, and I think I'm probably going to say a bunch of times it's the most significant. I find myself saying that over and over because the changes are so vast, but a big change is that we now have a definition of sexual harassment. You might be a little surprised to know that Title IX didn't have a definition of sexual harassment in the law, in the regulations or the statute before these new rules in 2020. We did have a definition, but it came from the Supreme Court, the US Supreme Court, which creates law. So it did have the force of law, but it wasn't written down by Congress, by the Department of Education in any regulation or statute. So now we have a very clear definition. We're going to go into that in just a minute, but you will see that definition has changed from OCR's perspective, and we have a much higher standard of when we're going to meet Title IX sexual harassment. Another thing I want to mention about the definition of sexual harassment, which is going to seem familiar to you, but it is important to note that it is the educational entity's obligation to comply with Title IX. Individuals in the organization cannot violate Title IX. It is the entity that violates Title IX because it is the entity that has to comply with Title IX because they are in receipt of the federal funding. So oftentimes, and this might happen from a student discipline perspective, maybe from an employee perspective, we say things like, you violated Title IX. Importantly, an individual can't do that. So what they have done is maybe engaged in Title IX sexual harassment per the definition. And then you will see that it is the obligation of the educational entity to take steps to both remedy that conduct and ensure that it doesn't happen again. So that's the first real big change. We have this definition, it's written down, we can see it, and we'll talk about it in a minute. We also have a narrow jurisdiction. So what does that mean? In schools generally, and this applies to, for example, our bullying law, that we engage, or we have to investigate or look into and possibly discipline, whether employees or students, that actually this applies to more often, conduct that happens in our school, but also conduct that has a nexus with our school, right? There's a connection. It might not have happened directly in our school building, but it has permeated our school environment. So it has come into our school environment and impacted our students. It has created a substantial disruption, or it significantly impacts the operation of our schools. Title IX now tells us that that's not the case. So under Title IX now, we can only address conduct that has happened in our educational program. And that's a big difference. While we might have other steps we have to take from a Title IX perspective, it's only what happens in our program. And again, that's a pretty big difference here. Now, educational program is broadly defined. So it's not just a school building, but it is also your athletic activities. It is also field trips. It is also school-sponsored activities that might happen off school grounds. Maybe you have a prom that occurs off campus. Maybe you're sending individuals to a conference. Maybe you have to use remote learning, and Tom's going to talk about that a little bit as we move forward. So it's pretty broad, not just the school building, but it is a difference. So if something happens relative to sexual harassment, Title IX sexual harassment, happens totally off campus, not in the school environment, it is not a Title IX issue anymore. Again, that's a pretty big difference. We also have some new definitions of knowledge, like when do we know? How do we know that we have to do something about this conduct that we might see or we might learn about, and the steps we have to take when we do learn. So very broadly, under these new rules, if we have I'm talking about the school, we have actual knowledge of sexual harassment in the program, in our educational program, the school has an obligation to take steps promptly and in a manner that's not deliberately indifferent. We have the definition of deliberate indifference. I'm not going to go into that today. It's a bit in the weeds, but safe to say that the school's obligation is to act in a manner that is reasonable, clearly reasonable under the circumstances. So when we know, we have to take that step that's reasonable under the circumstances, quite similar to a negligence standard, right? We have to do the thing that other schools would do. We have to do something as long as that would be reasonable under the circumstances. Another change, and again, a big change, because they're all big changes, is that we now have a very detailed grievance process that we have to follow as a school in the event that we get actual knowledge of sexual harassment in the school environment. And it is very safe to say that that is very far into the weeds as to what that process looks like. However, very briefly, there has to be an investigation and one or more individuals conducting an investigation, a separate person who makes the decision. They cannot be the same person. There is an appeal process. There is also a process by which evidence gets shared between parties, and it looks like a mini litigation, and really at this point, more so for sure at the college and university level, but there are very, very particular steps that have to be taken along the way. This just shows the response. And this is going to be parts of it important in your role, because you might receive actual knowledge, which I'm going to show you in a minute as to why that might happen. But really, actual knowledge means that any employee of the school district, of the educational institution, receives direct information that sexual harassment might be occurring. And so the obligation then is to report that conduct so that these appropriate, very, very detailed grievance process steps can be taken and the procedures can be followed appropriately. So once the school district has actual knowledge, like I mentioned, you have to act in a manner that is prompt. There are some particular timelines now under these Title IX regulations, and some of your policies and procedures probably have timelines as well. So we want to make sure that we act promptly. We report it without waiting, and we're going to act in a manner that's not deliberately indifferent, which essentially means we're acting reasonably, as I mentioned, but that we're following the steps, we're following the procedures. And then we have to make sure that our process is equitable. And under Title IX now, that equitable means a variety of things, but broken down, it essentially means that we're going to offer a complainant who's someone who's an alleged victim. We're going to offer that person immediately supportive measures, meaning we're going to provide them with a safety plan. Whether or not we do an investigation, we're going to say, we want to make sure you're safe in our educational program. And that's going to look very different in different circumstances, whether it's for students or for employees. It certainly might take a different road, but that is a requirement of the equity standard under Title IX, that we provide those supportive measures, that we explain the complaint process to any individual who's making a complaint. It also means that we are being equitable toward a respondent who is an alleged perpetrator. And under Title IX now, what that means is that if we have a formal complaint under Title IX, we may not discipline a respondent or an alleged perpetrator until we follow the Title IX investigation process. And that's a big difference for our schools, especially in the K-12 environment. This whole investigation process, which is quite comprehensive, has to be completed before we engage in any discipline. So I've said sexual harassment a bunch of times now in the past 20 minutes, and you're probably so curious, I hope, as to what this definition is and how it's changed. And we could talk about this definition for hours, I'm sure, but I'm going to do a quick snippet here. It's important for you to understand the definition of sexual harassment under Title IX because you should be knowledgeable about what information you should be reporting. And to be honest, when in doubt, we should tell a supervisor, we should tell an administrator that we saw this conduct, or we think this conduct may be occurring. That's certainly the most important takeaway here today. But here is the new Title IX definition of sexual harassment. This definition is a little bit different than we have in Connecticut law. It's also a little bit different than we have under Title VII, which is also a federal law that protects against discrimination on the basis of sex in employment. So we're working with a few different definitions here. This definition is now more narrow than it had been before under OCR's standards. So it's always conduct on the basis of sex. And we have to satisfy one or more of these three elements. You do not satisfy all of them in order to be considered, the conduct to be considered sexual harassment. It's one or more of these. The first one is what we call the quid pro quo. It's a this for that. It is that a supervisor who's an employee of the district conditions a provision or service on an individual participating in unwanted sexual conduct. It is a supervisor saying, I will give you a promotion if you engage in this sexual conduct with me, or similar type language. It doesn't have to actually be said. It can be implied, happens in a variety of circumstances. It could involve a teacher and a student. But if this happens, that is considered sexual harassment under Title IX. The second bullet is really the most commonly applied definition. It's the most common circumstance that occurs within our educational environments. And that's what we generally refer to as the hostile environment, which I'm sure is a familiar term. I'm sure you have all gone through sexual harassment training under state law and are familiar with that kind of concept. It is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it denies access to education. Lots of steps here, but safe to say that here are the differences. Under Title IX, it used to be, from OCR's perspective, from how they applied this law, the definition used to be severe, pervasive, or objectively offensive, that you didn't have to meet all three. And also the addition of a reasonable person standard. So all of these elements, severe, pervasive, and objectively offensive, are all looked at through the lens of a reasonable person, not the person who is alleged to have been harassed, which is a difference as well. And it is a little bit different than we see under Title VII and that we see under Connecticut law. So importantly, this is that Title IX definition. And it can be very, very confusing for all of us as to how they kind of intersect. But this is a change for us. This third element is also a new addition to the definition of sexual harassment. Very specific definitions of sexual assault, dating violence, domestic violence, and stalking. The definitions of these are taken from laws that apply in the higher ed context, but now they also apply in the K-12 context. So now we have a different definition of hostile environment: severe, pervasive, and objectively offensive. But safe to say, if conduct is severe, meaning it meets that definition of sexual assault, which is a very particular definition, it is still sexual harassment. So you could have conduct happening one time and it would still meet the Title IX definition of sexual harassment. Here's that definition of actual knowledge I mentioned. So the standard here is that we have to do something when we know, not when we should have known, and that used to be the rule. But the other change is that now it applies to every employee, and this is where you really come in. It applies to anyone who is an employee of an elementary or secondary school, meaning that you can receive actual knowledge, meaning you saw conduct that might rise to the level of Title IX sexual harassment, or someone informed you, right? They came to you and said, I am being sexually harassed. Here is what is going on. And sometimes, you being in the front line there, that this information certainly could come to your attention. The responsibility at that point, though, is to pass on the information. And this is actually not dissimilar from our bullying law. I'm sure you've all received information from your schools about reporting bullying conduct. And that's because you are considered an employee, as that term is quoted here, for purposes of state law. And this is our state law definition of employee. It includes all of the individuals we think it includes, but it also includes any individual who has direct contact with students and is engaged or under a contract with a school, with a public elementary, middle school, or high school. And that's pretty broad. Title IX tells us that any employee can receive actual knowledge. It doesn't give us a definition of employee, but we do in state law have a definition of employee. And this is the definition that we apply, which is why it's very important to report this information, because as you've heard, there are very particular processes that have to be followed once we have actual knowledge of sexual harassment, Title IX sexual harassment. These are some examples. It is what you think it is, right? What is sexual harassment? But not everything that's listed here will always meet the standard. Tom and I are always saying it's a case-by-case analysis, but that is so true under the law in most cases, and specifically when it comes to sexual harassment. Now, because of these narrow jurisdiction, we spend a lot of time saying, well, could this be Title IX sexual harassment? Is this something else that we should be managing in a different way? Safe to say, this is all bad behavior. This is not appropriate in our schools or environments of employment, whether or not it rises to the level of Title IX sexual harassment, right? This is bad behavior. And so steps should be taken in most of these situations, especially from a student perspective, and sometimes from an employment perspective as well. So there might be other board policies, other rules that apply, even if that standard isn't met for sexual harassment under Title IX. It's always on the basis of sex, this conduct, but it could be statements made, in public or to individuals. Maybe it's several statements over a period of time that becomes pervasive, right? That's that pervasive standard. It might be hanging up inappropriate lewd pictures that are visible to others. It might be touching. It might be requests for sexual advances or sexual comments, making sexual jokes, distributing sexual-based materials. And unfortunately, we see that in our student population sometimes. That can be incredibly complicated. A lot of this conduct often happens via electronic communications, which is a whole nother topic in and of itself. And it could also be the spreading of rumors, sex-based rumors, sexually charged names. It really runs the gamut. And we see, unfortunately, a lot of this happening in our school environments. So just some final thoughts on the Title IX piece. Report, right? If you have a question about whether this might be sexual harassment, the most important thing you can do is report the conduct, because there are a lot of specific procedures that have to be followed, and it's not your responsibility to figure out if it is Title IX sexual harassment. It's just an obligation to report, quite similar to what we talk about with DCF reporting. Do I have reason to believe this is happening? Yes. So I'm gonna report that information. And this information certainly might be DCF reportable as well under some circumstances. We have bullying obligations too. I just put that in here very briefly because our bullying definition has changed over the last year since we've all been together. And we just want to make sure we're reporting information that involves conduct between students so that the appropriate steps can be taken. And the last piece here is about policies and procedures. I know some of you are charged with updating policies, whether that's from a service that you receive updates from or what have you. If that is your part of your responsibility, we want to make sure that our Title IX policy has been updated at least since August of 2020, maybe a couple times since then too, because we've learned a lot since then based on these big changes. But that's something just to flag so that you can assist with that moving forward. And that's Title IX in a very quick half hour. We could spend a lot of time on it, but we're going to talk about now a lot of updates to Connecticut law. And Tom, I'll turn it over to you. I will change your slides for you.
Great. Well, thank you, Gwen, for that helpful overview of a complicated topic. There are a number of other changes, and just as as a overall comment, the 2020 legislative session resulted in almost no changes because of COVID, and the legislature was largely closed. But the General Assembly made up for lost ground in 2021, and there were extensive changes, and I won't be reviewing all of them, and Gwen won't either, but there are some that we wanted to bring to your attention. And the first is, as you see here in the slide, students now have the right to take mental health wellness days. So my question of you as administrative assistants is, where is your lobby, and why don't you have the right to take mental health wellness days? I think we would all enjoy this benefit, but right now the law provides this benefit to students and students alone, and students are entitled now by law to take 2 days off every year, subject to limited restrictions. Specifically, they can't be taken consecutively, and that includes Friday and Monday. But students have the unquestioned right to take a day off for mental health. And the definition in the statute of mental health wellness day is, as you see, a school day during which a student attends to the student's emotional and psychological well-being instead of attending school. So this plays into the whole process of determining whether absences are excused or unexcused. And let me just ask, do you think it matters when a person takes a mental health wellness day? And the answer is yes, it does. Since 2013, the State Department of Education has provided guidelines for when absences are excused and when absences are not excused. And those guidelines, which are available online, provide that parents may unilaterally excuse absences of students for the first 9 days, which seems a lot to me, but that's what they ended up with. But any day of absence past day 10, or I should say starting with day 10, has to be justified. If a student claims to be ill, there must be a doctor's note. Students' observance of a religious holiday, a death in the family, mandated court appearances, and probably the most interesting debate in this regard is over the parent who wants to take the child out of school for 2 weeks to go on vacation, saying that a family vacation is important and more important than school. And so what are you doing giving us trouble about that? The guidelines that are linked there, and you'll have access to this slide so you can look at this if you're interested. The guidelines provide that such absence will be justified only if it can be characterized as an extraordinary educational opportunity, which is pre-approved by the school district. And the guidelines provide specific criteria. So essentially, it's telling parents that school is important and that they need to send their children to school and schedule vacation when school is not in session. But this leads then to the question, well, where does this mental health wellness day fit in? And the statute itself doesn't really answer that question. But logic says, and we say, that if the student is taking a mental health wellness day before there's been 9 excused absences, it will count as one of the 9 unilateral absences permitted. But if for whatever reason a student has had 9 excused days and then wants to take a mental health wellness day, it's our judgment that that student is able to do that because the definition specifically states that the child can take those days, so that would be an excused absence. The law was also changed. As you may know, a definition of when a student is absent is if a student misses more than half a day of school, then they're absent. And so Section 18 of Public Act 2146 tries to address this issue of remote learning, which we'll talk more about as well. But the remote learning now is considered to be attending school if similarly the attendance is for at least half a day. So when as long as we're on the subject of excused and unexcused absences, we also want to bring to your attention something that was enacted into law some years ago. And that is that if a student's parent or guardian is an active duty member of the armed forces and being called to duty or returning from deployment, then there's automatic excusal for 10 days. And the school district can provide even additional excused absences. This law does impose upon the student and the parent or legal guardian the responsibility for obtaining assignments. But this is a special recognition of the contributions that people serve in the armed services. I see here there was a question, is it 9 excused days? So the question in the chat was, is it 9 excused days and can they add these mental health wellness days totaling 11 days? And the answer is, it depends on when the days fall. If the days are taken before the 9 are exhausted, then they're part of the 9. But if the 9 are exhausted, then the student would still have this supplemental right to take a mental health wellness day, and that would be excused. So whether it's 9 or 11 depends upon the timing of when the mental health wellness day is taken. Hope that's a helpful clarification. Turning back to this special acknowledgement of the rights of parents in the military, they may excuse their child for up to 10 days if they're returning from deployment or about to leave on deployment, and they're a member of the active duty or they're on active duty in the armed forces. So I'll move on to changes in school attendance. And some of us remember when kids only had to go to school between the ages of 7 and 16. And over the years, this has changed repeatedly. As you're probably familiar, students are now expected to go to school at age 5 and age 6, but they're not truant if their parent follows the procedure for excusing them from school. And that's not, like we were just talking about, excusable, but rather not sending them to school if they file a form with the district office. So kids are not truant only if at ages 5 and 6 their parents have followed the procedure. And on the upper end, the age for leaving school was raised first to 17, and now it's a year from July 1 will be 18. So students are required to stay in school until they're 18 years of age. But there's an exception And that exception is that if the child has reached the age of 17, the parent or guardian may withdraw the child, but only if the child is enrolled in adult ed program. Otherwise, a student who is not coming to school at age 17 will be considered truant. So that's another issue concerning student attendance. And we also have in Public Act 2186 the provision now for automatic enrollment for members of, for children of members of the armed services. As you know, when children and their parents present them for enrollment in the public schools, we go through a process of verifying their eligibility to attend school in your particular school district by asking them to show a lease, a deed, a phone bill showing that they're actually living in your district in order to enroll. As Gwen will touch upon later, before a student enrolls, we also have to receive a proof of immunization. So there are all these procedures. And just while we're on the subject, it's important to follow those procedures, because once a student has been enrolled, even if they don't meet the procedures, then the district can only disenroll them pursuant to a statutory process that provides for hearings, first at the board level, and then second, even at the state level, and possibly even going to a superior court. So we follow these procedures to verify eligibility for school privileges before a student is enrolled. You know about another exception, and that is under the McKinney-Vento Homeless Assistance Act. Students must be enrolled immediately, irrespective of their immunization status or whether they have a transcript or grades from anywhere else, if they are homeless. And so we need to enroll them immediately upon a claim of homelessness, and then we need to sort it out. And of course, whether or not someone is homeless is a definitional question that may be the subject of a hearing. But we do have that exception. Now we have this new exception that if we receive military orders directing the member to the state, indicating the transfer of the member of the military to the state, that is an automatic ticket to enroll a student in terms of residency. The immunization requirement is not waived in this case as it is for homeless students, but it's automatic proof of residency in Connecticut when a person shows those orders. Another change in the law relating to the military is that the State Board of Education is now directed to establish a Purple Star school program. And this would be an application process. School districts are not required to participate in this program. But the law does provide that schools can achieve this Purple Star school designation when they employ a staff member who serves as a military liaison, who compiles and makes available information and resources available to military connected students and their families, provides a transition program, given that the children of military families sometimes move more often than others, and offers at least one of the initiatives specified in the law. So we see through these enactments in terms of leave, in terms of enrollment, and now this Purple Star school program, a recognition by the General Assembly of the contributions that members who serve the country through the military provide. So we have these special statutory provisions acknowledging that contribution and providing special arrangements for children of members of the military. So the next topic that the General Assembly addressed is new requirements relative to collecting money for school meals. This has always been an area of some sensitivity where children who are not provided the funds to purchase a school meal may feel singled out or discriminated against. And so the General Assembly has changed the law to impose requirements to avoid identifying or shaming students over the payment for their breakfast, lunch, or other feeding. And so we see here in the statute that you can't identify the child publicly or say you haven't paid, so we're not going to serve you, or here's the substandard lunch that we give to kids who don't pay. We can't do any of that. They do have the right, or you as school districts have the right not to permit the purchase of a la carte items. But the general premise here is that students should be permitted to participate in the lunch program even when their parent hasn't paid the bill. School districts, because paying the bill is important, have to have a procedure for communicating with the parent as opposed to communicating with the child in order to collect some unpaid amounts. And the further details in the statute are that communication with the parents has to include information regarding local food pantries, the way by which they can apply for free or reduced price meals, and a link to the internet website describing community services available to residents of the town. And I was interested to see that now the law specifically says when the trigger is for unpaid charges. And you see here in the third bullet, or the second major bullet, that if the unpaid meals exceed 30, then school personnel are to refer the parent to the local homeless education liaison. Significantly, it doesn't say when you get to 30, then you cut the student off. So there's a great concern in the legislation for distinguishing the interests of the student and from the actions of the parent, and not visiting the any dereliction on the parents or inability to pay on the parents' part, visiting those consequences on the student. So then another change in the legislation relates to having a policy on grading. And as you may know, for over 20 years, there's been a requirement in the law, and that law is Connecticut General Statutes 10-20G, as in George. And that statute has required for over 20 years that boards of ed have a policy concerning weighted grading for honors and or advanced placement courses. For whatever reason, the General Assembly thought it important to expand that statute so that now the policy must describe the way grade point averages are calculated and whether grade point averages are weighted or not weighted. And it also must specify for not only honors or advanced placement courses, but rather all these other situations, whether there is to be a weighted grade in the case of a international baccalaureate program, a Cambridge International program, which I've never heard of, dual enrollment, dual credit, or early college. It's incumbent upon boards of education to review their policies. I had one district send me their policy, and I had to tell them they had to redo it because it didn't meet all of the statutory requirements for grading. We just need to try and stay on top of these policies, and that's one of them that we need to worry about. One of the more, I believe, controversial aspects of the legislation is trying to figure out the future of remote learning. Right now, and I believe it to be an oversight by the General Assembly, right now, remote learning is not permitted in general and will only be permitted in grades 9 through 12 starting next year, and only if the instruction is provided in accordance with the recently issued standards for remote learning. That is what the General Assembly enacted into law last year. Surprisingly, there's no provision in the law for going remote when there is a power outage, the furnace breaks, we have a snow day. I think everyone expected that after we learned how to deal with remote learning and ramped up and got sophisticated in making remote learning a meaningful educational opportunity, that this option would be available to students or to school districts in terms of continuity of instruction. In one situation, the argument is as follows. The district can pivot. It's through the challenges of the pandemic, it has developed a robust remote learning option. They can pivot to that instead of having a closure, because the result of a closure is that you add days at the end of the year. And so the question is, did we learn enough in the pandemic and when students were learning remotely that we can meaningfully continue education through a remote process? One may say yes, but the General Assembly so far and the State Department of Education has not said that that's permissible. And we are in the middle of, or toward the end of the new legislative session. So we'll see what happens. But one last point about the state standards that were issued. I guess we all have our opinions on this. In my mind, a standard is some objective criterion that must be met in order to qualify to provide the particular activity. These state standards that came out are, there are 8 different domains and about 15 pages worth of standards, including that the curriculum must be engaging, which in my mind might be a subject for debate as to whether that standard was met. So I hope that we continue to evolve in our thinking on remote learning and make this more accessible to students and school districts. Just Gwen, if we could go back to the last slide, I just wanted to speak a little bit about an exception. Thank you. And that is that notwithstanding the fact that there's no general authority for remote learning, except next year, in accordance with the standards, and grades 9 through 12. There is currently an acknowledgement by the Commissioner of Education that there can be circumstances based on individuals which would warrant and permit remote learning. And in a letter which is linked there, you can get to it later. If a student must be in isolation or in quarantine due to close contact with a COVID-19 case, that student may be educated remotely. And as the commissioner described, in rare and individualized cases, students with family members who have a documented and unusual vulnerability to COVID-19, they may be educated remotely. And finally, there are circumstances where the planning and placement team may determine that instruction may be appropriately provided in the home, but only if the PPT decides that that would be free appropriate public education in the least restrictive environment, and that judgment is reflected in the IEP. That's a tough row to hoe, as I think you would understand, because one of the fundamental principles of the special ed law is that children should be educated to the maximum extent appropriate with their non-disabled peers. So it would be an unusual circumstance, and the commissioner described it as rare cases. It'd be an unusual circumstance when the PPT decides that the student should be educated in the home, and that is for that particular student the least restrictive alternative. And finally, there's legislation concerning eligibility criteria for enrollment in advanced course or program. And in the statutes this year, the General Assembly has been concerned that educational opportunities be equitably available to all students. And as a result, they have adopted new legislative requirements. And now if a school district is trying to decide whether a child is eligible for enrollment in an advanced placement or other similar course, that decision can't be made exclusively on the basis of the student's prior academic performance, but rather, and any use of that academic performance must rely on evidence-based indicators of how the student will perform. Rather, these decisions have to be made more holistically. And we can't just do a simple review of a student's prior transcript in determining whether a child would be admitted to an advanced course. So I hope and trust there'll be questions later. I got through that more quickly than I expected, and I'll turn it back over to Gwen to talk about immunization.
Thank you. As you can see, tons of policy changes have been required over the past couple of years. The ones Tom mentioned most recently with the advanced placement classes and policies on grading, those are required as of starting this coming July 1. So you'll see a lot of policy changes coming over the next couple months. And obviously we will await and see what the legislature has to give us in a few weeks when they conclude their session. This was another big one, actually almost a year to the day, as I was reviewing what we've done over the past couple of years. I said, the timing of this again is right on track here. So a year ago, yesterday, I think it was, the law changed on immunizations and immunization requirements. And Tom mentioned earlier, and as you all know, students in the public schools and actually other private schools and colleges and universities are required to have certain immunizations prior to being admitted to the school. Tom mentioned a little bit about the enrollment process. Students are required, or families are required, to provide proof of residency That's the initial stage of enrollment. And then provision of immunizations before students are permitted to enter the school building is an important piece of this to protect the school community. Prior law had permitted an exemption, a variety of exemptions, one of which being an exemption to immunizations on the basis of religious grounds, and that is based on the religious beliefs of the parent or the student. That exception has been eliminated from the law. The law does still include exemptions for medical conditions based on certain information presented by physicians. But as of April 28th, 2021, religious exemptions are no longer permitted. Now, this, as you may have heard, was quite controversial. It led to very, very long hearings at the state legislature and changes to the original proposal for the elimination of the exemption, which led to what the law is now, in that there's a legacy provision in the law, which provided that if the student was already enrolled on or before April 28th, 2021, and had a valid religious exemption on file with the school by that date, then they could continue to use that religious exemption moving forward. There were a lot of questions about this right before really it was enacted. And the State Department of Education issued some helpful Q&A on the issue. And I didn't put the link here, I apologize for that, but it is pretty easily Googled if you're interested. It really dealt with what happens in the immediate. What does it mean to be enrolled in the district? What does it mean to have a valid religious exemption? And in general, what the Q&A provided was that the student must have filled out the appropriate paperwork and had it on file with the school, whatever that school needs for their purposes for either what they call enrollment or what they call registration with the school. We did see at this time a lot of students registering for kindergarten so that they could show that they were enrolled by the date of the effective date of the law. They also, though, had to have that valid religious exemption that applied to the prior law. That, when we say valid, it wasn't just a piece of paper. That document, which had to express that immunization was contrary to the students or the parents' religious beliefs, it had to be acknowledged, is the word in the law, by one of about 5 or 6 different individuals, just one, and that included a judge, a notary, the school nurse, but there has to be an acknowledgement on that form as well. So 2 pieces, had to be enrolled by a certain date, and then had to have that religious exemption on file. And as long as that occurred, then that would follow the student throughout their career in the school. There was no need either to receive the immunizations or to update that religious exemption paperwork at all. The Q&A also clarified, though, that this applied similarly to students who transferred from one district to another within the state, so that if that student had a valid religious exemption previously, prior to April 28th, 2021, in a different school district and they transferred, that exemption would transfer with them. Another question that did come up and it was addressed in the Q&A because it was quite timely was whether this applied to COVID-19 vaccination. And the answer from a statutory perspective very clearly was no. So the requirements for what students must be immunized against or what vaccines they must receive is statutory. So they're listed in the statute and the regulations, and they refer to a variety of schedules also. So that does not apply at all to COVID-19 vaccinations. I know many school districts, if not all at this point, were collecting vaccination status, and that was really to assist with contact tracing and to ensure that individuals were safe within the educational environment. So importantly, there is still a medical exemption. There are some students who cannot, for whatever reason, receive vaccines, and there is a form now on the Department of Public Health's website that has to be completed by the student's medical provider to express that there's an exemption, that for whatever reason, based on the child's health condition, that they cannot receive vaccinations and they are still exempted from those immunizations. Want to touch pretty quickly on some contract issues. I know that's quite a segue from immunizations to contracts, but over the past few years, there have been a lot of changes in the law as to what agreements school districts need to have for a variety of reasons. The most significant change was relative to student data privacy. And the second one, which came a year or so later, was concerned the provision of special education services. And they have somewhat different reasonings behind them. And I just want to touch on them a bit so that we're reminded that before we're giving student information, personally identifiable student information to third parties, there might be some requirements that we have to fulfill. To take it a bit of a step back, I'm sure you're all familiar with the Family Educational Rights and Privacy Act, FERPA. FERPA generally says we can't give personally identifiable student information, which is essentially information that directly identifies a student, to third parties without parent consent. And there are a variety of exceptions to that. We can share information within our school environment if we have a legitimate educational interest. But there are some exceptions that apply to giving this information to third parties outside of the school as well. We essentially, in this technology day, wouldn't be able to function as school districts if we couldn't or prevented from having vendors and third parties assist us with technology-related issues, with storing information, with maintaining our schools, if we couldn't give certain information to individuals who were deemed to be school officials or really agents of the school district. And that is how we use a lot of our educational technology. Rightfully so, there are a lot of concerns about student information being shared via the internet. And this is a significant issue in our country right now about how information is being shared, what information is being shared, and what are the protections on that information. There are a variety of other federal laws that apply. You might have heard of COPPA, which is the Children's Online Privacy Protection Act, or there's a law called the PPRA that also protects certain information that gets shared or could get shared. But the state of Connecticut implemented a law back in 2018, revised in 2019, to address this issue. And actually, Connecticut was one of the first. Colorado has a comprehensive law. California, and now a variety of other states have implemented similar laws, but Connecticut was really in the forefront of saying, well, we have to give this information because we need to use this technology in many cases to support our students and to allow them to be 21st century learners and move forward and become effective adults in terms of technology use. And so how do we protect that information? And in Connecticut, the decision was made per statute that we have to enter into written agreements with essentially vendors, right? Operators of internet-based programming or mobile apps before we can give them personally identifiable information. And some of you might be familiar with this because it gets flagged. There's often a list of approved, so to speak, technologies that can be used in the classrooms. And that reason is because it has to meet state law requirements, and embedded in that, it has to meet FERPA requirements. We have to make sure that both of those laws and sometimes others are met before we give over that information. The law in Connecticut includes a lot of definitions, and the definitions are quite important in this respect to determine whether we need this agreement before we can give personally identifiable information. What I often say to clients, though, is yes, we might need a written agreement under Connecticut law, but let's take a step back. Who are we giving the information to? Why are we giving the information? And do we need to give the information? And once we answer those questions, it helps us move forward. But from a FERPA perspective, we can only give information to a third party if an exception or parent consent is met. One of the most common exceptions, I talked about legitimate educational interest. That also makes the connection to the school official exception. So we can give information to outside third parties as long as they are considered school officials, which generally means that they don't have control over the information. The control is still on the Board of Education. We get to tell you what to do with the information. They've agreed to comply with all of our policies and procedures under student confidentiality requirements, and they're not going to redisclose the information. So they're not going to take that information and send it to someone else. So those are kind of the first steps that we always like to ask. And then we have to decide if we need a contract in order under Connecticut law to provide that information. So I said already that it applies to operators. So any organization or entity or person that operates a mobile app, an internet-based program that we're providing the information to, in your context, that applies to, for example, Google. It applies to Power School. And so the question becomes, how do we get into a written agreement with these very large organizations, Microsoft, Apple, on some occasions, and what does that look like? Well, you're all probably familiar with downloading an app on your phone and pushing accept to a terms of service. You know, sometimes we scroll through, sometimes we probably just press accept and we move forward. Well, the minute you push accept, you've entered into a contract, right? There's no requirement for a signature in Connecticut on a contract and in most states. And actually, in many circumstances, there's no requirement for a written document. Now, under this Connecticut law, it has to be in writing. And many times that terms of service will meet your written requirement obligation. The question, though, is whether that written agreement complies with all of these requirements of Connecticut law. And sometimes the answer is yes, and sometimes the answer is no. And if the answer is no, we often enter into negotiations or discussions with the vendor to say, well, we need this compliant agreement. Many school districts have a model student data privacy agreement, a sample that they or template that they provide to vendors. Sometimes vendors provide their own. When it comes to the big organizations, they have already, most of them, changed their terms of service for Connecticut. They have a Connecticut compliant terms of service. And the state did some work in the beginning to make sure that those were negotiated with organizations like Google, which was pretty daunting for an individual school district to have to negotiate. Because importantly, the law says that this written agreement with the operator has to be between the Board of Education and the vendor and the operator. It is not with the state. And so that okay, or I accept on terms of service, any employee of your district can go ahead and push accept, but were they authorized to do so, and is the agreement compliant? So a couple things that have to be included in those agreements, and there are 10 very specific obligations. Lots of our school districts like to put in some more stuff because they want to make it more specific, and that's okay. And some vendors are willing to negotiate on these terms, but important that these 10 terms are included. I have not listed all of them here, but these are some kind of broad categories of what those requirements are. Some of them mirror FERPA, and in fact, one of the requirements that has to be in the written agreement is that the vendor agrees to comply with FERPA and that both parties will comply with their obligations under FERPA. The agreement has to say that the Board of Education maintains control over the data, which is very similar to what FERPA requires as well. The agreement has to explain how information can be deleted. How can we contact you to say, you need to take away all of this information from your databases? You have to delete all of it. The agreement has to include what happens if there's a breach of data. So what happens if data gets out there into the internet? What steps are you going to take, or do we have to take, in order to contact students, parents, individuals who need to know that their information might be out there? But also the agreement has to talk about security and confidentiality. You have to tell us what steps you're going to be taking to ensure that this data isn't going to get out there onto the internet. The law also requires or prevents, and this is not one of the 10 requirements, but it prohibits operators who meet this definition from using targeted advertising, meaning that we're going to use your program or your app, but you can't sell stuff to our students while we're doing that. And the definition of targeted advertising is very, very narrow and particular to Connecticut, most specifically. They can't do that. They also can't sell our data. That's prohibited by law. So there's a whole list of things that, while might not need to be included in your contract, are also prohibited if a vendor were to receive student information pursuant to this law. So a lot of protections really embedded in that Connecticut law over a period of time as the changes have come along. Currently, there's no very specific enforcement mechanisms, although there are some broad enforcement mechanisms in Connecticut law about what do we do if we're not complying with these rules. And importantly, it becomes a standard of care. You know, if information does get out there and something were to happen from a negligence perspective, this becomes our standard, right? If we're not following these rules, have we breached our standard of care? So it's quite important that we make sure if we need a contract, before we send student data or personally identifiable student data generally, then we get those documents before we send out the information. Another contracting requirement that was new in the last couple years is that, and sometimes I think to myself, we didn't do this in the past, because I think sometimes we did, but it seems just so important, is that if a student is placed on an IEP and is placed out of the district at a private placement, private special ed school, then there must be a written agreement between the private school and the Board of Education. And that seems pretty basic that we would have that agreement, but sometimes it wasn't happening. And as many of you might know, the special education process can move sometimes very quickly and sometimes very slowly. And there is a need when a student needs a private placement to move quickly and get that student into the placement so that they get the supports and services that they require in order to receive a free, appropriate public education. The law only talks about private providers of special education. There's certainly a concern at the legislature, and I think from boards of education perspective, that prices of special education services are getting quite extreme. It is very, very expensive, as many of you know, because I know many of you deal with budgets and special education placements and records. It costs a lot. And so there's a concern that we ensure that the services being provided match those in the student's IEP, and that the costs for such services are very clearly outlined in that contract. And that's a mandate of the law now, that you have to have a written agreement, and it has to explain how the costs are broken down. So where are all the costs coming from? And we know that we're talking about very high need students from an educational perspective. And so oftentimes there is a need for quite significant costs, but that has to be detailed in the agreement. There's some other information about what may be included in the contract, and we certainly encourage school districts to have comprehensive agreements when it comes to private placements. And that's because private placements don't necessarily have to comply with a lot of the rules that public schools do, except that they become then an agent of the school board. And so we want to make sure that there's knowledge, that they're aware that they have to comply with certain rules. It talks about, detailing the services to be provided. We can put that in there. How do we maintain our records? We like to put that information in there, that these are FERPA records. They belong to the Board of Education. How long are the services going to be? When do the services occur? There's a whole variety of information that should be included in there, including some standard contract language that we do prefer be included. And that applies to those student data privacy contracts as well. In fact, just to take a quick step back to the prior slide, that two of those 10 requirements in the student data privacy contracts are that a provision that Connecticut law applies to the contract, because many of these vendors and sometimes the private placements are outside of the state and based in other states, the laws of which we might not be as familiar with, and we would prefer that our state law apply, but that's mandated for vendor agreements for student data privacy purposes. And then it also is required for data privacy purposes that there be a provision about severability of the contract, meaning that if one provision is deemed unlawful, that the rest of the contract will still be intact. That's just some basic contract language that we prefer be in these agreements. There is also a new provision over the past, I think it was 2 or 3 years ago, that there is now a requirement that private placements in receipt of funding for special education purposes are audited. And that audit of these private placements has to happen at least once every 7 years, but not sooner than every 5 years. And there's kind of a priority list in the statute. It's essentially private placements that, first of all, there has to be a mix between the private placements that are approved and that aren't approved. And then the private placements that receive the most funding get audited first. Another part about this special education contract piece is that if we don't have this contract with a private placement, we are prohibited as a school district from receiving excess cost. So big motivator, some of you know who deal with excess cost in special education, it's a lot of money, and it is a provision of the law that permits you as a school district to recoup certain funding from the state after you've reached 4.5 times past your per pupil spending on a student. So it becomes a big loss if a district isn't able to recoup that kind of funding. So it's really important that we have these contracts and that we are abiding by them and we know what they say as well. I think that's the end of mine, Tom. Do you have anything to add before we?
Yes, given our efficient presentation, I thought that we could take another little bit to provide a refresher on FOI issues, because I know that administrative assistants confront these issues all the time. And so some of the points that come up are, first, you get an FOI request, and the FOI request is for something that is readily available. Do you have 4 days? Because the law says that public agencies that requesting parties can consider a failure to provide the information within 4 business days to be a denial, and then they can file a complaint. Well, actually, you don't have 4 days. You may have 4 hours, or you may have 40 days. It depends on what the person is asking for, because the legal requirement is that we respond to FOI requests promptly. And so that's going to just depend on how easy or hard it is. I won a case at the commission one time where it took us 6 months to respond completely to a request. But there are other circumstances where someone shows up at the board offices and says, can I have the copy of the agenda of the meeting 2 weeks ago? And it would take you about 30 seconds to go find it and give it to the person, or at least give the person access to it. The commission may well say that to tell the person you'll have the answer in 4 days would be inconsistent with that legal requirement. As you know, I've never been in a circumstance where someone's made an FOI request because they like what you're doing and they want to be supportive. Usually FOI requests are made because someone's either curious or more likely disgruntled about something or else. And so what we've found recently is that people are making very broad requests that can actually be impossible to fulfill. So what the question is, do we have the right to go back to the person and say, this is ridiculous, what do you really want? And we're here to help. And the answer is, you can do that, and you should do that. I would say that most FOI requests, whether people are disgruntled or not, have some basis in curiosity, and they want particular information. It's important to come across as collaborative and cooperative. We want to help, but we don't really know what you're looking for. And if we just take your request as written, it's going to take us 6 months or a year to provide you those records. So let's have a meaningful conversation about what is the purpose of your request. I don't know if any of you have gotten into this next common problem, but we get increasingly, there are requests for emails, again, very broadly. And we can't just turn emails over because there may be confidential student information or attorney-client privilege communication. So we have to go through these emails. Both Gwen and I have been involved in requests for 1 million emails. If you actually just look at what they're asking for and look at what's available. So in those cases, it's important to work with your IT person. The commission has actually been very practical and realistic in this regard. The commission has agreed that a diligent search, which is the requirement for records requested under the Freedom of Information Law, a diligent search can include using keywords that you would then have your IT person search on. So you don't have to read 1 million emails, but you identify the emails with the key concepts or terms. That still might only narrow it down to 50,000 emails. So it's an iterative process where you try to zero in on things. Again, most people are cooperative, and sometimes we can agree with the requesting party that we'll search on specific names or specific terms, and comply with the request in that way. Some of you communicate with the full board on matters. And when you communicate regarding the date for a meeting or an agenda, that's fine. But if you're polling the board for response on a particular substantive topic, it's important that you either caution them or blind copy people so that they can't do reply all. The Freedom of Information Commission has, excuse me, repeatedly found that discussion of board business by a quorum of the board on email is in fact an illegal posted meeting. So it's a little treacherous. You or the person you work with sends an email out and to a quorum of the board, and board members respond, reply all. And it doesn't take too many of those emails, like it could be two, before the commission will say that that's a discussion. And interestingly, the statute defines a meeting under FOI as communication among a quorum to discuss or act upon a matter within the jurisdiction of the agency. So sometimes people think, well, we didn't make a decision, what's the problem? But the law considers a discussion really the process that requires a public meeting. And the last point I'll make in terms of just a refresher on FOI issues that come up most frequently, we sometimes get requests for information in personnel files. And as I'm sure you know, when certain information in the personnel file is requested, we have to notify the employee, and the employee may lodge an objection saying that that's private and they object to the disclosure of the information. Sometimes people think that we just tell the person, hey, there was an FOI request concerning information in your personnel file. What do you want us to do? And the person says, well, I don't want that information released. And so we hold it. In many cases, that would be a violation of the Freedom of Information law, because the threshold question is, when a request for information in personnel files is made, do we have a reasonable basis to believe that some or all of that information would be exempt from disclosure? If we don't, we have to release it. And we don't offer the employee the opportunity to object. It's only on those marginal things like teacher evaluate. Well, that's not marginal. The teacher can object to the disclosure of their evaluation. But we have to look at the request, promptly provide the records that are requested, unless we believe that they could implicate the privacy interest of the employee. And it's only those records that we withhold on the basis of that employee's objection. Now, one thing that has changed in the law is that let's just say that there's someone who is asking for names and addresses of public employees. This may be offensive to you, but that is public information, and we have to release it. Sometimes it's information about a particular employee, like, hey, how much does that high school principal I don't like make? And that's public information, and there's no reasonable basis to withhold it. The question that would come up is, well, should we tell the high school principal that someone's mad and asking for personnel file information? And historically, we've taken the position that that's just common courtesy, that if someone was asking for my personal information, I'd want you to tell me. So we would typically tell the employee that this request was made, even if we have no ability to withhold it from disclosure. Under a change in the law in 2019, we now have an affirmative obligation to notify the employee that this information has been requested. And we have to provide that notification around the time we provide the information if it's not exempt. And if it is exempt, obviously, we have to give the person a chance to object. But there is this change in the law now. We affirmatively must notify people even when the FOI request does not implicate any of their privacy interest. It just implicates them. And we have to tell them that this request was made. So it is now 10:15. And I hope that that quick refresher on freedom of information issues that you confront was helpful to you. And I know Bill is going to moderate this opportunity for free legal advice.
Well, thank you, Tom and Gwen, for two terrific presentations, so comprehensive and full of information. We'll get to the questions. And we had one come in through the chat, which we can start with. And the question is, are we legally expected to do remote learning? I think it means for this school year, for extended school year ESY for special ed students, says because of due to the July 1, 22 date of grades. I'm not sure I exactly understand that part of it, but I guess is there a requirement to do remote learning for extended school year for special ed students this school year?
I'll defer to Gwen.
Well, I think safe to say that there isn't a requirement to do remote learning at all, right? And in fact, the guidance for grades 9 to 12, because I know in the question, I can see that they were addressing the 9 to 12, which as Tom talked about, the law change will permit remote learning in grades 9 through 12 only in accordance with these guidelines and the policies of the board, but it's never required. Would it apply though, would these rules, I'll interpret this as, would these rules apply to ESY? And I think the easiest answer is yes, the rules would apply in grades 9 through 12 because our school year runs July 1 through June 30th. So that's the school year. So technically ESY actually occurs in the next school year, although we call it as part of this school year, but from a legal perspective, the school year starts July 1. So I think from a technical perspective, we could apply those rules. However, caution, because we also have to provide a free appropriate public education. So while we might have these rules permitting remote instruction in certain circumstances in accordance with the guidelines and in accordance with any policies and procedures, we also have to take into consideration the provision of a free appropriate public education. And that could be a complicated analysis. So certainly in every case, we're not mandated to provide it, and it would depend on the policies, procedures of the individual school district and compliance with these new guidelines. I think, and Tom, let me know what you think, but I think it's going to be the rare circumstance that remote learning is implemented even in accordance with the quite comprehensive guidelines that were provided, and schools are going to be, as they are now, doing their very best to keep kids in the classroom.
I agree with that. I think the limitation, which I hope is somehow addressed in this legislative session, to remote learning in grades 9-12 creates a real problem for school districts if they want to use remote learning on an emergency closure day, because then you could take care of 9-12 and as long as you meet the standards, but your lower grades would have to come back for that extra day. So I hope that that's addressed, but right now that's where we are. So as a result, I think it's going to be the rare school district that provides for remote learning in grades 9 through 12. But it's just an evolving issue and we'll have to see what happens.
Yeah, well, we're all paying a lot of attention to that, and I'm sure there's still changes to come. Some other questions. Is the state still permitting virtual board meetings?
I have a news flash. The governor signed a bill yesterday. You may recall that in that big 700-page bill that the General Assembly passed special act or June special session, Public Act 21-2, included provision for continuing virtual meetings that had been started through the governor's executive orders, and then they all expired. So the General Assembly authorized those meetings in that public act. And it said in section 149 of that law that these virtual meetings could continue until April 30th, 2022. Well, that's why the governor's action was timely, because now he has bridged essentially what they did in this law that was essentially enacted yesterday, is they removed the April 30 date. So what has been permissible and continues now to be permissible without time limitation. And public agencies can certainly always meet in public. That's fine. But now they have the opportunity, or they continue to have the opportunity to meet hybrid, that is in person with also remote participation, or completely remotely. And I must say that that's a wonderful flexibility as we come up against time-sensitive issues. It's one thing to get a quorum of the board to physically attend a meeting, but you can much more easily get a quorum of the board to attend a virtual meeting at different times of the day. We need to post those meetings at least 24 hours in advance. And some of those meetings, there's special rules. You have to post some of those meetings 48 hours in advance. But the flexibility remains. So the very timely question, and I'm happy to say that April 30th will not now deny public agencies the opportunity to do their business through remote means.
Kind of related to that, how about other types of meetings, like PPT meetings? Can those be held virtually, or is there any legal requirement about in-person, virtual, hybrid?
I can take that. Yeah, so I can address the special education piece specifically. So the law has actually always provided that we should provide some flexibility to the families in order, or parents is the language of the law, to participate, and has included both federal law and state law in including, but not limited to, telephonic participation. And we all know that statutes are slow to catch up with the times. And there's no prohibition. It's an including but not limited to obtain the parents' participation. And in fact, I was just speaking with a director yesterday who said, oh my goodness, it is so much easier to organize a meeting. We know that PPTs are sometimes so difficult to schedule, especially when parents want to bring additional people and the school district wants to bring additional people, and you're coordinating a lot of schedules. But parents specifically are now really able to participate much easier if they can log in electronically. I think we all know it's not ideal. Today's a great example. Would be really wonderful to all be in person if we can. And I certainly prefer being in person. I think it brings that connection to the meeting, and we do lose a little bit of that when we're virtual. So I wouldn't make it the baseline, right? We're not going to presume all the time everything's going to be virtual, but there is that flexibility for PPTs and for parent-teacher conferences. That's been a big one too, in your regular education setting, to afford the opportunity to participate virtually has been so helpful. Can get a little complicated for school districts. I know that from experience, juggling between in-person and virtual meetings, but it's a 15-minute conference, especially at the elementary level, and to allow parents to pop in virtually is really helpful for a lot of people to be able to do that. So I don't see that going away. I think that's one of the positives of our technology, is that we're able to engage parents more. There are many, many, many parents who are working, and how do we engage them and allow them to participate, give them the opportunity to participate when they have full work weeks, and taking time off is just not possible. So this has been a welcome change, I think.
That's great. Good information. This is kind of a follow-up, I think, to Tom. For like a board meeting, does it have to be well, I'll just read the question. Are they allowed to only stream the meeting, or does it have to be something that provides an interactive component like a Zoom or a WebEx? If you understand the
I do.
the implication.
I'm processing the question. I would view live streaming as a supplementary activity, but I think you just described it as direct participation. People have to be able to attend the meeting in that, however you want to define that. And so I think that you do have to provide access to the meeting through Zoom or WebEx so people can attend. You don't have to let them talk. That's up to the board to decide whether and how to let people talk, although you would be guided by your bylaws. The school board would decide whether to have public comment in a particular meeting, and if so, it only makes sense that the public comment could be permitted to the people in person or to the people remotely. But I think that falls within the discretion of the board. And I know I see the question then extends to, well, what about Board of Ed subcommittee meetings? And all the rules are just the same because subcommittees are public agencies and boards of ed are public agencies, town councils are public agencies, and all of these rules come out of the excuse me, come out of the Freedom of Information law, and that law applies to all public agencies. So we would have just the same rules for subcommittee meetings, but the practical interest in, say, live streaming a policy committee meeting may be very different. There may be a distinction drawn as a practical matter between live streaming a Board of Education meeting, or even a practical difference between live streaming a regular meeting versus a special meeting. That's all just optional. But when the meeting is remote, if some members of the agency are permitted to participate remotely, then that same access should be given to the members of the public.
Great, thank you. Another question. Do you know why the state requires parent excuse letters, this is regarding attendance, to be in writing? We have parents who get angry when they receive a attendance letter, even requiring a written letter when they've called it in or provided some electronic means of notification.
Tom, you want me to jump in, or you
no, I was
have a thoughtful answer?
No, go ahead. I was just looking at the verb dojo, the teacher.
Dojo. Yeah, no, I know what that is.
Okay, well, go ahead, Gwen.
Yeah, Dojo is an app, so it's a communication tool between teachers and students, teachers and parents.
Oh, I thought it was some verb which involved confrontation. But anyway, I'm glad to be here with Gwen, who knows what she's talking about.
Well, who has
Gwen.
2 elementary students and 1 middle school student, so I'm up on my my terms here. So it's a good question. Why? So first of all, the requirement is in guidance. It is not in the law. So there's no statutory or regulatory requirement that it be in writing, but it is in the state's guidance, which is what then is put into many of your board policies. And so that is likely where the requirement comes from. I know in our model documents that we create, we do include that in our regulations as a requirement. Why is always a good question. There's no legislative history here to look at, but this is me kind of presuming the reason here, because again, it's not a legal requirement, is that they just want to make sure that it was the parent who made that communication. And this is another way of trying to assure that. Unfortunately, there are circumstances, mainly at the high school levels, that calls get made in that by people that aren't the parent. And so this is just another way of kind of assuring that it is the parent who made that that call in or the email that was sent, what have you, but that it be actually physically in writing and not sent through an email document. And I hear you, because I haven't gotten an attendance letter yet, but I certainly get some reminders, right? Send in that written documentation so we can make sure that that absence is excused. So I feel that, but I do think it's just that kind of, let's have some additional assurance that it's the parent and the parent knows where the kid is.
Right, thank you. Another question, any tips on schools posting photos with students on social media?
I could talk about this for a long time, but do have some thoughts. Couple things. So let's start with FERPA, right? We started with FERPA when we started talking about contracts and sending personally identifiable information. FERPA actually includes another exception for directory information. Directory information, and your school district should have a directory information notification, and it is almost like a page-long document that explains what directory information is. That's a general proposition. It is information that we don't generally view as private, but would fit within personally identifiable information and things that we couldn't disclose. Student pictures, student photos are included in directory information. From a federal law perspective, we can include that, but we need to make a decision as a Board of Education. Are we going to include photos in our description of directory information? Many of your districts do, if not all of them. And that's kind of how we publish our yearbook. That's how we can send a photograph to the local newspaper back in the day. And now social media has really come in to be part of this. There is a requirement under directory information, two things. We have to give the notice and we have to permit an opt-out. So we have to tell parents or eligible students that they can sign a document annually to say, I don't want you to release any directory information. So very safe to say that if a parent opts out of directory information, we cannot post the student's picture anywhere, even in the yearbook, let alone social media. So the rules really apply the same, whether we're giving that information to social media or we're giving that information to the local newspaper from a FERPA perspective. FERPA doesn't, or state law doesn't specifically talk about social media. There are other considerations really to think about here that are more practical, and who has access to the information? Where is that information going? Is it something that we want to be posting? What other information are we posting? We have to be really careful about putting anything personally identifiable that's not directory information. And sometimes information can be linked, right? We happen to post two different things and then we're able to connect some more information. So we have to be really cautious about that. So there are some additional steps, and I would look to your board policies and procedures in terms of what you designate as directory information, and make sure that there's a process for identifying which students have opted out, because that can get lost pretty easily, to make sure that there's a document that is very clearly identifies those students.
Right. Well, I'll encourage folks in the audience to pose some additional questions, and while they may be thinking of those and typing those in, I'll ask a question, kind of a follow-up to your presentation on Title IX, Gwen. How do topics, related to sexual or gender identity get affected or impinged on with Title IX?
A great question. And in fact, if I, had my druthers, we'd be talking about Title IX all day. And that's an important piece of it. So the rules and the interpretations of Title IX have changed over time, right? Depending on the administration's views or goals, interpretations have changed. And so we've seen really this pendulum kind of back and forth as to whether Title IX applies to issues related to discrimination on the basis of gender identity and expression and sexual orientation. Now, taking a tangent for a second, is that Connecticut law, since I think it was 2011 or 2012, has protected against discrimination on the basis of gender identity and expression and sexual orientation, probably even before then. So there's no question in Connecticut that we may not discriminate against individuals on that basis. But the federal law, has not been as clear. We know right now, there's a whole history we could talk about, but right now the Biden administration has made very clear through executive order, through instruction to the Department of Education, and then OCR has come out with guidance documents expressing very clearly that Title IX applies to discrimination on the basis of gender identity and expression and sexual orientation. So if those issues were to arise within our school environment, and circumstances, do happen, that we have to treat them as Title IX matters, as well as state law matters, and make sure that we are comprehensive about that. It's a great question, and certainly an issue that's been raised at the Supreme Court recently, and also, by the way, applies to Title VII from a federal law perspective. So the prohibition on discrimination in employment on the basis of sex also applies to gender identity and expression and sexual orientation. And that's very, very clear from the Supreme Court. But we are going to see revisions to Title IX, maybe within a day. They were saying that the Department of Education said they'd be out in April, so they don't have much time left. We're thinking maybe the beginning of May, we'll have a new revision to Title IX. But the rulemaking process, takes a really long time. And so we probably won't see any changes that are effective for another year or two, even if we get a draft. So changes are coming, more changes.
Mm-hmm. Something came in on the chat. I think it goes back to your previous question, and it says, what exactly is considered, I guess, directory information? So which information is, would be included in that?
Sure. So the federal law lists as a definition of directory information, a lot of information. That includes photographs, student name, student address, student telephone number. I can't list them all off the top of my head. It also includes athletic related information, such as height and weight, if you're on a sports team, honor roll designation. I really encourage you to go to your board policy. You for sure have a definition of directory information there. You can eliminate some of those things per your policies and procedures, but that's the definition that the federal law gives it under directory information.
There's quite a bit of flexibility in that regard. The regulation under FERPA says information that's not generally considered to be an invasion of privacy. And it's a little counterintuitive. We all, although I guess this is less common, but we all know about how the honor roll is published in the newspaper. And the question is, well, what do you mean the honor roll? Doesn't that reflect student grades? And how is that not an invasion of privacy? But the definition of directory information includes honors received. And if that honor is received, but interestingly, I had a FERPA complaint by some parent who was upset because the honor roll was published. His daughter was not on the honor roll. And by negative inference, we were revealing her grades. That didn't go very far, but it just shows the different perspectives people bring to these issues. But as Gwen said, the key is, what have you done in your district in terms of directory information? And have you notified people that that's what you're free to release that information, but they have an opportunity to object. And it can be quite catastrophic if, and this can occur in the case, say, of an abusive relationship. A parent says, I don't want any information about my child being published. And they may have a very good reason for it. The law contemplates that that parent has that privacy right, notwithstanding the fact that the information would be otherwise considered directory information. So that notification and sensitivity to who did request confidentiality is really important.
Thank you. Well, I'm going to ask all the questions that I've always had. So since we don't seem to have others coming in, but this is something that I think might very well happen to administrative assistant in a principal's office, where a student comes in and says, can you change my name in Power School? I want to be called by my nickname, or I want to be called by this other name for whatever reason. What can they do that?
Gwen's the expert.
Well, first I'll give you the Tom Mooney answer about changing your first name, right? This is my favorite, Tom, that I always remember, that you say that you can change your first name no matter what. You can have yourself called whatever you want, and it's not unlawful unless you're trying to pull a fraud on someone, right? Now, from a perspective of schools, your obligation is to prevent discrimination, not discriminate against individuals on a variety of protected classes. This issue comes up most frequently in the schools when individuals, students would like to change their name because they have changed their gender identity. And we get these questions almost every day from schools. And the State Department of Education has some great guidance, some pretty clear rules about what we have to do so that we're not discriminating. And that's really the standard here. Do we have to change a student's name? Because if we don't, we're going to be discriminatory against them. And the State Department of Education's guidance says we do not need a legal name change. In fact, and this surprises many usually, we don't need parent permission to do that. And in fact, in some cases, and this is a very case-by-case basis, and my guidance to schools is always, this is a very thorough, comprehensive conversation with the student as to what parents are aware of. And in some circumstances, students are transitioning and parents are not aware. And we have to be very sensitive to that because this protection is for the student, right? We have to protect against discrimination of the student. It's not the parent. And so we do change students' first names and we change them in records moving forward. There's a different process that we might need to go through if a student, and sometimes this happens, the student and parent comes in and say, my student has changed its gender identity and we would like all past records changed to identify that this was the student's gender from the beginning of their entry into school. And that's a whole process we go through. But when a student comes in and says, I would like you to call me a different name, I've changed my pronoun or changed my identity as from male to female or female to male or any other options that are available, we do that and we make the change. And it has to be in documents moving forward. And the concern being that if it's not, and for example, I had a question recently about a transcript, that transcript is what gets sent after the student graduates to colleges, universities, employers. And if we were to have a different name on there that wasn't the name requested by the student, the concern is that we are discriminating because we are revealing the transition or the transgender status of the individual. And that could be, it could be a violation of federal law actually now. So we have to be really careful about that.
Thank you. All right, well, we'll have this be the last question. Can you talk about Connecticut General Statute 46B 56G? I think this could be valuable. I don't know what that statute is, and I think the person presumed that you would.
Well, I'm honored that the person thought I would know what 46B 56G is. I don't. I can take a quick look. Well, Gwen.
I'm looking, hold on. I'm looking.
And we have had 2 follow-ups about name changes.
Okay, well, let's deal with those and I'll look at that statute.
Changing last name, a parent wants to use a mother's last name versus a father's last name, that kind of thing. And then something about a student's name change. We were told the student must keep their original email. Why is that? So those are name change questions.
So, the last name change question is the last name change question is an interesting one. And I don't know that I have a clear answer really off the top of my head. Generally speaking, we would need to be able to identify who the student is. And when the student enrolls in school, we ask for copies of maybe a birth certificate or identifiable information. And the need would be to ensure that this is the same student, right? For sure. Now, there are definitely times that students go through legal name changes, and there is no prohibition from requiring a legal name change document relative to the student's last name. That certainly would be my preference, because that does happen, that there's custody cases happening and some family unit issues going on, and there's a change. And I would recommend that there was some documentation of that. Certainly asking is the first step. As long as it's not related to gender identity or expression, there's no discrimination related issues, at least that I can think of off the top of my head, but that's certainly a collaborative discussion, with the administrators and with your legal counsel too. Was there another question, Bill, that you had mentioned?
It was
original email?
Yeah, something about a student's name is changed. We were told that a student must keep their original email. That may just be the convenience of the of the school district, right?
It certainly might be, and this is where technology gets in the way of the law sometimes. I'm often told, we can't do that on the electronic form, and I said, well, the law requires you to do that, so print it and write it in. And that might be the issue here. There's certainly no legal issue, and I'd be concerned about a different email address popping up for a student who doesn't have that name anymore. Certainly depends on how it comes up when they are emailing. It would depend on a lot of things. The goal here is that we're not indicating anything about the student's prior name. That should be kept actually in a private location, and it shouldn't be indicated on any official documents.
Right. All right. Well, we'll make this last one.
Well, I can speak to the.
Okay. Go ahead.
The statute refers to the non-custodial parent access to records.
Gotcha.
And that's also contained, I believe, in 1015B. So, but that is the way this works, is that non-custodial parents have the right to access student records unless the court has modified that access. So I just wasn't familiar with the iteration of that concept in 46B 56 subsection G. But it's an important thing, and in fact, recent legislative change was that non-custodial parents can request and be entitled to notice of school events in the same way as custodial parents. So I appreciate the chance to just reinforce that concept that non-custodial parents have those rights.
Well, I really want to thank you, Tom and Gwen. We've put you on the spot here for quite a long time this morning, but with such excellent information, very thorough, really addressed so many issues that are important in schools today and that our listeners need to know and I know appreciate hearing from. So just again, thank you, your expertise, your wisdom. We just are very grateful for your coming on this morning, always being so gracious to us at CAS, sharing your knowledge with us. And we look forward to having you back and hopefully in an in-person environment when we're next able to do it. So thank you so much. Really appreciate it. We are going to take a short break right now. Just a reminder as well that we've recorded the conference and we'll do so for the morning and we'll put that on the CAS website to share. When you have a chance, we'd like you to take our evaluation survey, and the link there is on the screen and it will also be in the chat. Please take a minute to complete the survey. Your feedback is really important to us. So thank you for being with us this morning. Stay tuned for part 2 of the conference. We will be back at 11 a.m. sharp when we announce the recipient of the 2022 Administrative Assistant of the Year Award, and then we'll share a special tribute to all of our amazing administrative professionals. And you won't want to miss that, and there's lots more to come.
Welcome back for the second half of our 2022 Virtual Administrative Assistant and School Secretary Conference. And if you're just joining us this morning, we are glad that you're here. And now it's time to announce the 2022 Administrative Assistant of the Year recipient. Here to give us the big reveal is Diana Burns, one of our CAS Elementary Board of Control members, chairperson of the CAS Ropes Networking Committee, and principal of Chapman Elementary School in Cheshire. Please join me in welcoming Diana Burns to announce our 2022 Administrative Assistant of the Year. Take it away, Diana.
Thank you, Rosie. It is my honor to announce this year's Administrative Assistant of the Year. As I read through the nomination letters for this individual, I was truly blown away. Those who know her shared some incredible comments. One colleague shared that even when this administrative assistant is literally juggling a telephone, a walkie-talkie, a copying machine that's not working, morning announcements, 17 subfolders, a pile of forms, 99 emails, and a student who can't find their phone, she never gets frustrated or impatient. She continues to smile. And in the midst of all that chaos, she makes you feel that she's not too busy for you. Her colleague continued to explain that they would not know what to do without her. How would they survive? The school building would literally fall to the ground. In summary, this individual defies definition. Another colleague stated that this administrative assistant is a master of her craft and probably the most organized person she has ever met. She is beyond dedicated, and she functions as if all 108 employees and 634 students are members of her immediate family. That is one family I want to get adopted into. Further, they shared that they are grateful that she keeps her day job because, quite honestly, she'd be an amazing teacher. She'd be an incredible principal, and she could be, and maybe should be, the superintendent of schools. And there's more. Her colleagues also stated that this administrative assistant seems to know everything. If you need an answer, this is where you go. You go to her. She is a first ballot Hall of Famer. I know you're wondering, is this individual even human? I was wondering the same thing, and I'm convinced that she is superhuman. The superhuman, incredible 2022 Administrative Assistant of the Year is June Rydzik. Congratulations, June. And June, could I get your cell phone number? Congratulations.
Thank you so much. We appreciate it. My name is Kurt Ogren. I'm lucky, very fortunate to be the principal at Woodland Regional High School and to work with June Rydzik. She's been here since the building opened. We've been open for a little bit over 20 years, and it's been an incredible journey. All those things, wonderful things that you said about June are absolutely true. I'm very proud of you, June. June, one thing I do want to say is whether you're a student, whether you are a faculty member, staff member, a parent, or just somebody in the community, just by talking to June, whether it's on the phone or coming on in to our building, June makes you feel like family. And that's absolutely true. And I appreciate that. I can't say enough great things about you. Very deserving award. Congratulations on being the 2022 CAS Administrative Assistant of the Year. Congratulations.
Thank you so very much. I'm so honored and
You're
grateful.
welcome. You're welcome.
Thank
So
you.
congratulations, June.
Yay! Sorry, I'm the only one that you can see at the moment, but I hope that all of our attendees are clapping and celebrating your wonderful award. And it's so great, Kurt, that you and Woodland Regional High School nominated June. So congratulations, June. You are also fortunate to have June at Woodland Regional High School as your lead secretary since day one. I can't believe that, which was September 4th, 2001, when students first entered the school hallways. So again, you're truly amazing. And as Diana said, superhuman. So keep up the great work, June. And again, congratulations. We did have a number of outstanding nominees this year for the award, and I would also like to commend each of them. I will not read their names, but I hope that their administrators and other school personnel who nominated them will let them know how much they too are appreciated and loved for everything that they do. So again, thank you to all of our administrative assistants and secretaries for the great job that you're doing, and keep it up. I told you there'd be a few surprises this morning during our virtual conference, and it's time for us to give away a very exciting door prize to one of our lucky attendees. We have placed the names of everyone who has registered to attend the conference into, whoops, I thought maybe if I blurred my screen, it would work, into this virtual bowl, which you can kind of see. Maybe if I go back a little bit, there you go. Anyway, we put everyone's name if you registered into the conference bowl, and we will be drawing the name from this bowl for the door prize. The Legacy Theater, Brantford's own regional professional theater on the shoreline, is incredibly excited to be back with its opening main stage production of the 2022 season, I Do, a charming musical about marriage. The show will play Thursdays through Saturdays at the theater from April 28th through May 14th. And so we hope if you have a chance, you get a chance to go down and see that play. But we are excited to announce, and I'm trying to watch my bowl at the same time, but we're excited to announce that today's door prize is 2 tickets to Brantford's Legacy Theater performance of I Do. The tickets are for the May 14th 2 p.m. matinee, and we greatly appreciate and thank Legacy Theaters for their generosity. So the time has come to find out who our lucky winner of the 2 tickets to I Do on May 14th will be. So as you can see, I am dropping them all in, and I'm going to reach clear down into the bottom so you can see that I definitely do not know whose name I am picking out. But right now, I would like to congratulate Teresa Rivera from Stratford, Head Administrative Assistant at Stratford Academy Victoria Soto School. So congratulations. I don't know if you can see, you can't really read it, but congratulations, Teresa. And we will get someone to contact you either today or early next week about your tickets and how we can get those to you. So again, congratulations, and a special thank you to Legacy Theater for supporting our conference today. And now it's time for one more special surprise. I know I speak for all of the administrators across Connecticut when I say we couldn't do it without all of you, our amazing and dedicated administrative assistants and school secretaries whose quality of work, dependability, initiative, and positive working relationships deserve recognition, and a huge thank you for the important contributions that you make to provide a safe and nurturing school climate and overall school experience. You are truly the heartbeat and the lifeblood of our schools. You keep the schools running efficiently and effectively. In fact, I would venture to say that, like me, and I mean this in a very good way, most administrators would agree that you, the school secretaries and administrative assistants, run the school. Without you, I don't know what any of us would do. So for all of these reasons and many, many, many more, we want to thank each and every one of you and recognize you for all that you do every day to make a difference. So to each of you, this special tribute is from all of us to all of you. Enjoy.
Good morning to school secretaries and administrative assistants from around the state of Connecticut. I'd like to take an opportunity to sincerely thank you for all that you do to support all school stakeholders. You truly are key in supporting the educational environment for students and staff. You truly do it all and make a difference. You're the first face that parents in the community see when they enter our buildings. Most of you probably know all the students in the building and build strong, trusted relationships with them. And you are some of the best multitaskers in the school, juggling 3, 4, 5 jobs at once. You do it with a smile and a can-do attitude, and it does not go unnoticed. You're the backbone of the school, and we could all not do our job without the amazing and talented people like you making that all happen. Hope you enjoy today's conference.
Ms. Fitzgibbons and all the administrative assistants, we just want to say how much we appreciate you and everything that you do.
And no one knows that better than our own kindergartners.
I don't have any idea. What's Americans weather? They watch and see other people to make sure that they're safe and if there's any fires, then they'll tell the people to get out. We get phone calls. Type. jokes to each other. Sit on the couch. Do soup sometimes. They play games. So from the bottom of our hearts,
I have to say it, and I cannot lie. You, yes, I'm talking about you, are phenomenal. There is nothing that I could do without the help of my office staff. Thank you for being phenomenal. People who greet, who coordinate, who organize, who have our backs and make us shine every day in every way. Phenomenal.
I want to say thank you to all the wonderful Connecticut administrative assistants. The last couple of years, we've needed these more than ever, and I want to thank all of you for being our hard hats, protecting us, helping us navigate through all these challenges. Schools could not run without you. Thank you for keeping us sane and all the great work that you do.
Here at Chapman School, we have the most amazing
Office Squad.
Can you tell us a few things that you do?
Order supplies.
Attendance.
Answer the phones.
Schedule meetings.
Arrange coverage for teachers.
Respond to emails.
Make deliveries to teachers.
We alert everyone when wild animals like bears are on the playground.
Check in tardy students.
Buzz visitors in.
Monitor the halls.
Morning announcements, producers, and anchors.
Meteorologist.
Lost and found department.
Therapist for students.
Therapist for parents.
Therapist for teachers.
There is no question that our office squad is essential, valued, irreplaceable, appreciated, and most of all, they are loved.
An ode to our secretaries and administrative assistants. Who do you see when supplies run low, and who is always in the know? Who do you see to get the latest scoop? Who's always there to keep you in the loop? Who's always reminds you of important dates? And who takes over when you're late? And who do you see when you need to know the rules? Honestly now, who really runs the schools? Our secretaries and administrative assistants.
On behalf of our building, to extend a deep appreciation and thank you to our amazing and outstanding administrative assistants for Administrative Assistants Day. We're fortunate enough to have 4 of them: Ellen Mari, Patricia Gazzafi, Glennie Montanari, and Carolyn Hamilton. We deeply appreciate all of the work that you do on a daily basis. You truly are the lifeline of our building, and we couldn't do it without you. So on behalf of Scottsburg Middle School, I just want to say how much we appreciate, value, and cherish you, all 4 of you. Thank you.
Hello everyone, Jason Lambert here, principal of Martin Kellogg Middle School in Newington, Connecticut, and I am honored to have the opportunity to pay tribute to our awesome school administrative staff who have been absolutely phenomenal, especially over the past difficult 2 years. This one is for you. You got a heart of gold with all the school biz. You're smart and helpful and a Google whiz. Everyone knows who the real boss is. I want to thank you, secretaries. You're kind and patient when I complain, keeping it simple for my bird brain. Secretaries keeping us from going insane. I want to thank you, secretaries. I want to thank you, thank you, thank you, secretaries. I want to thank you, thank you, thank you, secretaries. Thank you so much, secretaries. You rock.
The Connecticut Association of Boards of Education thanks all of our administrative assistants working in our schools and in our central offices. You are the consummate professionals, and you hold your schools and your school districts together, especially in these very challenging times. We also thank our own administrative professionals here at CAID, Gail, Will-Marie, Corey, Pam, Terry, and Nancy, and they have a message for you. Thank you. You're the best. Thank you, everyone.
Hello, administrative assistants, and thank you for all the work that you do throughout the year. We know as principals, as athletic directors here at CAS-CIAC, that really the work within the school couldn't be done without your help and assistance. Every day you make a difference, not only in the days of the lives of our students, but all the staff that you engage with. Thank you for everything that you do on behalf of us here at CAS-CIAC. Thank you.
Again, you are amazing at what you do. And as you heard, you are loved, you are appreciated, and you truly, truly make a difference. Thank you, thank you, thank you to all of our administrative assistants and secretaries. And now it's time for our second session this morning. Here to introduce our speaker to you is Charisse Miller-Odukwe, Director of Student Activities at CAS, and my colleague and friend. Welcome, Charisse.
Thank you, Rosie. Originally from the great state of Missouri, Kate was an only child raised by a strong single mom on unsweet tea and playing outside and old school Nickelodeon cartoons. Growing up small compared to others her age, Kate always felt the need to try to chase that pesky little thing called perfection, which was a losing fight. And in working with youth for over 10 years, Kate can see the same chase for perfection in teens that she saw in herself. She uses her story of being told she was never good enough to becoming a performer at Walt Disney World to becoming an author and gladiator, not because anyone saved her, but because she learned how to save herself. Kate is lucky enough to have called the stage home since she was a young girl. Kate has performed as a dancer and actor in Orlando, Florida, including Walt Disney World, Universal Orlando, SeaWorld Orlando, Legoland, and recently joined the Shake the Ground Dance Competition Tour as their resident MC. In 2019, Kate published her first book based on her keynote talk. Please join me in welcoming Kate Garnes.
Ah, Charisse, it's so good to see your face again, my friend. It's been so many years. Oh, hello, everybody from sunny Florida. I wish that I could be with you in person, getting to love on your hearts in person, but here we are, and we are making the most of what we've been given, and I am just so grateful. I'm so grateful that I jumped on. I got to hear some of the other speakers earlier and their incredible advice and knowledge. Like, I just sat here. I'm not even an administrator, and I'm sitting here like taking notes and listening. It was so good. And then to get to see that tribute video, and as I'm sitting here sipping my coffee, waiting, it literally just hit me. I am in the presence virtually of the backbone of Connecticut schools. And it is just such an honor to get to be here with all of you and to get to, I'm so excited. Okay, so let's jump right in. Man, we've been through it in the last 2 years. Like, I know when we all started our careers as secretaries, as administrative assistants, that this is not what we thought it would look like. The last 2 years are not what we thought it would look like, especially when I know down here in Florida, it was, we're gonna take a 2-week break. And that 2 week turned into 2 months, which then turned into what felt like forever. But there was something that I noticed. And I will tell you that as a professional performer, my career came to a grinding halt because all of a sudden I wasn't traveling for speaking for teenagers, and I wasn't performing anymore because it required large groups. But I noticed something. So as I'm sitting on my couch for days on end, which I literally never usually do, I'm scrolling, doom scrolling through social media. And I noticed that the pandemic was all anybody would talk about. March 2020. Literally, I live in Florida now. I'm originally from Missouri, and all of my friends from every walk of my life was talking about the same thing. Everybody was talking about the pandemic, social distancing. We didn't know about masks at that point. And I sat back and I had a moment. Also, there's a solid chance that my cats have zero personal space, so they will probably come and make an appearance at some point here. It happens. Just so you know, you're not surprised. But I'm sitting and I'm looking at like my mom in Missouri and my cousin in Michigan and my friends in California and my Disney friends here in Florida. And I was like, man, we are living with so much intention right now. There is so much intention and attention to detail and intention on how we are living. We are intentionally wearing masks. We are intentionally social distancing. We are intentionally taking our schools virtual when like most of our teachers and you all and everybody's like, what does that even mean? What do you mean we're going what? But we did everything with so much intention. And I remember sitting in this exact seat and having a moment of, okay, hang on a second. What if for one day, just one day, we took all of that intention that we have been putting toward wearing our masks, toward social distancing, toward trying to stay informed, trying to make smart choices for the safety of ourselves and our family and others. What if we took all of that intention and put it toward loving others? Like, can you imagine if for one day or one moment, everybody, instead of posting about the pandemic like they were in March of 2020, posted about loving others, posted or showed intention toward trying to understand people who may not look like them or vote like them or speak like them or pray like them? What if just for one day, we focused all of our intention and had so much intention that we were doing toward all the stuff toward that? And I'm going to take it a step farther. What if for one day, no, we won't even say a day. We won't even say a day, y'all. We'll set the bar decently low. What if for 1 hour, we took all of that intention and put it toward loving ourselves and put it toward honoring ourselves and taking care of ourselves? And that, because I want to encourage you, please use the chat. Please, if you hear anything that you love, anything resonates with you, please toss it in the chat. Because right now, I just look like I'm talking to myself, even though I know all of you are out there doing amazing things. So if something hits you, please share it in the chat. But we as administrative assistants and as leaders and as administration, and you know what, as human adults, as breathing human adults, we get this idea in our head that we come last, that we have to make sure everyone else is taken care of, and that the ball is still rolling and the train is still on the tracks, and everyone is fed and everyone is good. And please tell me that I am not alone in this, but we tend to believe this lie that if we don't fall into bed exhausted at the end of the day, where we have given everything we have to everyone else, and I'm not just talking about your schools, I'm talking about your families, I'm talking about your community, I'm talking about your churches, I'm talking about your hobbies. We believe this lie that if we don't fall into bed at the end of the day, completely spent, completely exhausted, that we didn't try hard enough. We believe this lie, and I don't know where that lie came from, but we learned this lie of if I'm not solving all of the problems and fixing everything in my job and at my school, and if I'm not giving everything to my family at home, and I'm not exhausted by the end of the day, then I didn't give enough. And that's a lie. And it's a lie that we've believed for a long, long time. I like to call this my give cup. I have a give cup. All of us have a give cup, right? It's the cup that when we're doing really well, when things are going really good in our lives, our cup is full. And it's easy to give people some from our cups, right? Now, imagine that I have my give cup and that Charisse calls me up and says, oh my gosh, Kate, I need help with this project, this thing. And I'm like, girl, I got you. And I pour a little bit from my cup. And then, whoops. And then Kathy calls me and says, oh my gosh, can I please talk to you about this thing? It's really heavy, but like, I gotta get it out. Girl, you can talk to me all day long. And then Adam calls me and Adam's like, oh, I got this thing. And then Sam shows up at my door and says, I need your help with this. And yeah, absolutely. Give. I'm gonna move myself backwards a little bit because I feel like I keep hitting myself. Give, right? Until finally, there's nothing left in my give cup to give. And Diana calls me and says, I don't even have a give cup anymore. And I'm like, here, take mine. We've believed this lie that we have to give and give and give, even when we don't have anything left to give. This is burnout. How many of you have felt like this in the last 2 years? I know I have a lot. Burnout. This is exhaustion. This is what happens when we think that we have to come last. And when we have to not take care of ourselves or our own heart. Now I want to flip the script a little bit and say, now imagine that got my cup. And I know the things that fill my cup. I love a good cup of coffee. Hands up for those who love a good cup of coffee. Yeah, I love a good cup of coffee. I enjoy a good cup of coffee. That goes in my cup. I like to read. And I like to read like not just any books. I like to read really funny murder mysteries. Like not really serious. I like funny murder mysteries. Pour that in, right? I like going on walks sometimes, unless it's summer in Florida and then it's like the surface of the sun here. So I don't go on walks then, but I like going on walks. Pour that in. I really, really love binge watching Netflix. I'm not sorry. I'm not going to apologize for that. Pour that in, right? I love good actual phone conversations with my close friends. Pour that in. All of a sudden, I'm filling my cup. And then when Mary, who said, yes, absolutely, Mary gets me. Mary, you get me. Well, Mary calls me and she's like, hey, I'm going through this thing. And like, this is really hard. And I say, Mary, I've got you. And instead of pouring out, because I've been pouring into myself, pouring into my heart, pouring into my own soul, what happens when we pour into a cup? It overflows. So all of a sudden, all I have to do is move my cup toward Mary. And she is then not getting the weird backwash stuff at the bottom of your give cup that no one really ever likes. She is getting the very best of me because I've taken care of this first. Self-care is not selfish. Please hear me when I say that. Self-care is not selfish. And again, we like to believe that lie of, but I have to make sure that my family is taken care of. I have to make sure that my students know I am a safe place to go. I have to make sure that my principal has everything that they need. I need to make sure that the wheels stay on the bus and that the bus is moving forward, because once the wheels fall off the bus goes down the hill, and then somehow it's my fault. I don't know if anyone else feels like that. Whenever things go chaotic, whenever things happen, all of a sudden, at least I will say, well, I didn't try hard enough. I have to try harder. I have to do better. And then we give and we give and we give and we give and we give until we show up and we're exhausted. I want you to imagine for a second, June, first of all, June, congratulations on Administrative Assistant of the Year. That is amazing. Imagine that we all jumped on a Zoom call, or we had a meeting and June was there. And obviously, June, you are doing an amazing job. You are clearly the backbone of that community. Now, I want you to imagine that June shows up on this call, right? She shows up on this call and she probably like has like, oh, there's the cat. She shows up on this call and her camera turns on and it looks like her house has been hit by a tornado. And she says, "Oh my God, I'm so sorry. I am here. And there's like mascara kind of like that, like, you all know what I'm talking about when the mascara kind of runs. And it looks like she looks so tired and she looks so drained. And she says, "I'm so sorry. I am here for you. I am here for you. Whatever you need, I'm ready. I'm here. How can I help?" I'm guessing none of you would want that for June, because June gave and gave and gave and gave and gave and was giving to you at the expense of her own mental health, at the expense of her own joy, at the expense of showing up looking like her life has kind of come undone. Please toss in the chat, would you want that for June? Would you want that for whom your leader is, whether it's a principal or a teacher or anything? Would you want your leader or the person who you are working for or with to give and give and give and give to you, knowing that they are taking a hit because of it? Chat is silent. Good. My guess is no. None. I watched how all of you in the chat were like, "Congratulations, June. June, that's awesome. Congratulations. You are the best." All of this stuff. I'm guessing none of you would want that for her. And yet, for some reason, we think that that's okay for ourselves, especially after the last 2 years where, y'all, we didn't even have a give cup anymore. Like the wheels were off the bus. No one knew what was happening. We were all just trying to survive, quite literally. I know for me, when it comes to who I follow in leadership, that the people who I connect with, whether it has been working for Disney or or other companies or other entities, are the leaders who aren't afraid to say, "I think I need a minute. I think I need a minute. I need a mental health day. I don't think I'm doing so hot, and I'm gonna be okay. I'm gonna be all right. But this is what's happening, and I need a minute." I will follow that leader over a cliff. I will, those are the people who aren't afraid to show me that they love themselves enough to set boundaries. And I get it. I am preaching to the choir right now. I am preaching to the people who quite literally are the backbone of your school, of your communities. But I also know that even backbones break. And our backbones get tired, and our backbones are literally miracle workers, because it's someone, I was trying to write down names while I was listening, but someone even said, "I don't know what I would do without you. Without my administrative, I don't know what I would do without you." And I know that can, at least if someone said that to me, which is such a huge honor and a huge compliment, but it also with it comes a lot of pressure. The pressure to feel like you can't mess up, the pressure to feel like you have to be all things to all people. I loved in the tribute video where the three ladies were talking about all of the things that you all do. Like, not only are you answering calls and solving problems and putting out fires, but you also are being the therapist to your principal and the therapist to your students and the nurse, maybe sometimes having to get the students to the nurse, and with that, I feel like, can you stop, please? With that, I feel like can come a lot of weight and a lot of heavy and a lot of pressure. So I want to show up today for all of you to say, I hear you. And I beg you to take a moment, even though I'm sure that there are some of you out there going, Kate, that's really cute that you think I can take time for myself, but I have this. I hear you. And I know, and it is hard, especially when we have all of these obligations. I want to ask you, what fills your cup? What fills your cup? I'm not asking what fills your sister's cup. I'm not asking what fills your friend's cup. I'm not asking what fills your parents' cup. I'm asking what fills your cup. And I want you to, on your own, make a list. Maybe it has 5 things on it. And if you are comfortable sharing, I would love to know some of the things in the chat that bring you joy, that Marie Kondo your life. What are things that bring you joy? I named a couple for me. I love chocolate chip cookies, especially the kind when like you like lift them up and they kind of like do that. I love watching Netflix. I love documentaries. I love candles. I have a candle lit back here because they just bring me solace. And I'll tell you what, I have a list. I have a list because when we get into the thick of it, when we get into the heavy and the time of the year when students are needing to, Amy said the beach, reading and children. The beach, sun, reading and children. I love that. Come down to Florida. Our beaches are great, except when they're sharks, but our beaches are great. When we get into the thick of it, when we get where we have deadlines and where we have demands on our time and all of this stuff, we forget. It gets a lot harder to remember, oh yeah, I do like a bowl of ice cream. Oh yeah, I do love reading. Oh yeah, I probably should go to the beach when I have an off day. Oh yeah, I love playing cards with my family. I mean, I can only speak for myself, but I know that when things get heavy and things get hard and things get stressful and I feel overwhelmed, I forget those things. Julia said, reading with a cup of tea or a glass of wine. Yes, absolutely. Yes. Those are the things that I big time encourage you. Make a list. Doesn't have to be a long list. Doesn't have to be an Excel spreadsheet. You don't have to put it in alphabetical order. This is 100% for you. And guess what? As long as it's legal, there isn't a wrong thing to put on this list. There isn't. I don't know if that makes you feel really freed, but that makes me feel, oh, I don't have in my list of things that make me feel like I can breathe again. I don't owe that to anybody. Nobody needs to see it. Nobody's going to judge you for that because it's for you and you alone. Reading with a cup of tea. Oh, that sounds so good. Maybe I'll do that later. That just sounds like, I love it. So, make a list, put it somewhere that you can remember when you feel that, oh man, I feel exhausted at the end of the day. I am tired. I am spent. I don't think I have anything left to give. I'm gonna past me is looking out for future me, and I'm gonna look at my list and I'm gonna do one thing on that list, knowing it will make me feel better. I know. So when I was going through a really tough time in my life, many years ago, I had hit rock bottom. And let me rephrase. I thought I had hit rock bottom until the pandemic. Then I hit a whole new level of rock bottom. But I hit rock bottom. And I was very, very tired and very, very lost and very, very weak. And a show had come out called, Scandal. And I mean, I was the level of exhausted, ladies, I think you'll understand what I mean when I say this, where like, you know, when you put your hair in a ponytail and then you haven't showered for a hot minute, and then you take the ponytail holder out and somehow your hair still stays in the ponytail. Yeah, I was that level of tired and sick of adulting. That's where I was at. And a show had come out called Scandal. And in the very first episode, if you don't know anything about Scandal, it's Kerry Washington. She's a Washington fixer. Anyway, in the very first episode, one of the characters on the show says, "We are gladiators in suits." And that resonated with my soul. I don't know if you have ever had a song lyric or a television show or a quote or anything, when you hear it, like the world slows down. That was this for me. And I got up out of bed and I went in my bathroom and I wrote, "I am a gladiator," on my bathroom mirror. Hand to God, true story. And prior to that, I had been listening to the lies that everybody had been saying to me, that I was small, that I wasn't worth it, that just a lot of horrible things that no one should ever have to hear. And I looked at the words, "I am a gladiator," and I stepped back. And for the first time in a long time, I saw a light in myself that I hadn't seen, that had been very much snuffed out. And I let that be the thing that I told myself over and over and over. I am a gladiator. That is literally the only thing I allowed myself to think. I am a gladiator. 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 Kate, you're stupid. Nope. I'm a gladiator. Kate, you're ugly. Nope. I'm a gladiator. Kate, why is anyone ever going to want to listen to you? Because I am a gladiator. That's why. I found my battle cry that day. And fast forward to mid 2020, where I thought I had known rock bottom. And I sat on my living room couch and I realized that rock bottom has a basement. And I had made a list. I had made a list of things that I knew had worked to pull me out of that in the past. And I sure did walk into my bathroom once again, after having, at this point, I had been a speaker for teens and middle schoolers for 2 years. Charisse has seen me give my gladiator talk. And so I knew I'd been speaking on find your battle cry, know your worth, right? And when push came to shove and my little booty was sitting in the basement of rock bottom, I remembered what had worked for me in the past. I remembered how to find some light in the past. And you better believe I walked into my bathroom with a dry erase marker and I wrote, "I am a gladiator," on my bathroom mirror again, because I'd made a list. I had made a list of how to find joy, of how to find meaning, of how to save myself again when the pressure was too much, when the sadness was too heavy, when I felt like if I blinked too much, I would just start crying. I don't know if any of you felt like that over the last 2 years, but I leaned on the things that I had set myself up for in the past. I made a list of, I am a gladiator, no matter if I'm not working right now, because we can't have large groups of people. If I can't perform in Orlando because we can't have large groups of people, I am still a gladiator. I will still be a gladiator. Even when I'm sitting at rock bottom, I will lean on the things that matter for me. what are the things that pick you up? What is something that you can do for yourself every day to remind yourself that you are worthy of love, that you are worthy of joy, that when it feels like school's on fire and there's a lot of fires we got to put out and everybody's running around like a chicken with their head cut off, how am I going to make sure that I take care of my heart so that I can take care of others? Oh, Denise said, you're amazing. Oh, thank you. Thank you so much. Thank you. Your words, I need to focus more on self-love so I can be a better me for myself. Absolutely. Starts with you. I know we believe this lie of everyone else has to be taken care of before I take care of myself. And if I go get that massage, and if I have that glass of wine or that cup of tea at the end of the night, or if, I put a lamp in my office instead of the fluorescent lighting, or if I take 30 seconds to listen to Michael Bublé sing to me, or Frank Sinatra sing to me, I'm gonna let him sing. It's gonna be my own private concert, and I'm gonna let that happen. That 30 minutes that you took does not make you selfish. That 30 minutes that you took to pour into your own heart, to hit your own reset button, does not mean, guess what? Everything is not going to burn down around you if you take that 30 minutes for yourself to make sure that you are okay. You know what, y'all? I'm going to go there. I'm going to go there. Surprised I haven't gone there yet. We got to put our own oxygen mask on, even though everything inside of us is telling us, no, I need to make sure that my principal has their oxygen mask on. No, I have to make sure that student council is doing okay and they have their oxygen mask on. I have to make sure that this student who's going through some really heavy things at home has their oxygen mask on. No, I need to make sure that I am not ever messing up on the wrong pronouns for the student who has just opened up to me that they've changed their pronouns or that they want to be addressed by a different name. I need to make sure I never mess up. I've got to make sure that their oxygen mask is on. I have to make sure that all of the sports and the PE teachers and the librarians and the custodians and everybody else, does everyone else have their exit buddy? Does everyone else have their oxygen mask on? Okay, now I can put mine on. By the time that you have gotten out the words, does everybody else, y'all are passed out in the plane. And that's really hard because everything inside of us is screaming, no, it's fine. It's fine. I'll be fine. I'll be fine. I can just do this. I can just add this one more thing. I can just take on this one more deal. I can just help this one more student and then I'll take care of myself. And then I'll eat lunch. And then I will drink more water. And then I will let Mike Bublé sing Sweet Nothings to me for 30 minutes. And then, until you realized you've gotten to the end of the day and you haven't eaten. And that's why you have a headache. And that's why you're shaky. And that's why you snap at your husband or your wife when you get home. And that's why, and that like taking that time, self-care is not selfish. In fact, self-care to me is very selfless because y'all listen, I am a heinous human when I have not eaten and when I have not slept. My name is Kate. I call that version of myself Catherine because she's not nice. She's not nice. And nobody wants to be around me when I'm not nice. And I don't know if any of you are like that, but to me, by giving myself self-care, by doing what I need to fill this, to take care of this, I am taking care of those around me. I am much more patient when people want to vent to me. I am much more patient when the 7th grader wants to come in and tell me their life story. You tell me, child. Tell me how you've had your heart shattered, how you've been in love and had your heart shattered. I am here. I am all ears. You know, I am much more patient when my principal has had a bad day and they're more snippy than normal. They're usually very good to me and they're more snippy than normal. It's all right. You know what? because I've taken care of this. And at the end of the day, you are the only one who can take care of this. You are the CEO of your own lives, my friends. Ooh, that's like a really, I mean, it's true. I don't know if I'll say that again because it's like, that sounds really like hoity-toity, but it's true. Nobody is going to care more about you, your well-being, and your mental health than you, because everyone else, as much as they may want to, I know that Charisse is an amazing human. I know that she cares about me as a person. Yep, I do know that. I have hugged her. She gives great hugs. But I also know that she, at the end of the day, she needs to not worry about me and my mental health. She needs to be making sure that she is okay. How are you going to start making small choices? Y'all, I'm not talking about eating the whole elephant. I'm talking about making one thing per day that is for you, that brings you joy, that makes you go, oh yeah, okay, I can do this. Maybe it's setting boundaries. Maybe you give yourself 30 minutes where you can eat your lunch in peace. Nobody gets to tell you what to do. We are in your sanctuary. Maybe it's setting boundaries. Maybe it's setting boundaries of, I leave the school at this time. And I know, some of you just laughed. There was laughter. I know, I heard it. Just remember, even when we set those boundaries, it's for your own protection. It's for your own health, to be able to take care of yourself so that you can take care of everything around you. I know when all of this insanity, the dumpster fire that was the last 2 years happened, I was sitting right over there on my couch and I was like, oh man, you know, a little bit about me. I have always been the type of person that was go, 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 go. Yes, I can add this to my plate. There's no room on my plate. That's fine. Just like put it on top. It's fine. I have always been that person, running myself ragged, chasing money in jobs, taking on more and more gigs. And I remember sitting on my couch right over there and saying, I don't think I want to do that anymore. I don't think I want to live that life. You know, now that I've been forced to stop and forced to breathe and quite literally forced to not leave my house for weeks on end, I think when everything opens back up, I don't want to do that. I also think that when things open back up and we are able to safely, I'm going to hug everybody. Did anyone else feel like that? Like, and not like little hugs, like I'm going to bear hug people because I have been so deprived of hugs and I'm a physical touch person. I'm going to hug people, but mostly I'm not going to allow myself to put everything back on my plate that I was doing. And then the world opened back up. And what did I always know? I always knew chaos. I always knew putting myself last. I always knew saying yes to everybody because I didn't realize that no is a complete sentence. And so I just piled onto my plate until I got to a point where I was like, wait a second. This is exactly what I said I wasn't going to do. This is exactly where I said I didn't want to be anymore, because I've said yes to a whole bunch of things that do not bring me joy, that I'm doing for the sake of someone else that I don't even like. What am I doing here? Did any of you have anything like that over quarantine, over the last 2 years, where while you were trying to juggle all of the things simultaneously, where you said, I think when the world opens back up, that I'm going to do this. I'm going to take more time with my family. We are going to cook more at home. We are going to actually go to church on Sundays. We are going to, I don't know, eat more fruit. I don't know, you name it. Did any of you have anything like that over quarantine? Because I know I did. And I also want to challenge you to listen to that. listen to those things that you told yourself in that time when there was a little bit of stillness in the everything, the world has been flipped on its head, and these are the changes I want to make when normal comes back. Add those, make another list. I'm surrounded by a lot of administrative assistants and secretaries, so I know that you all like making lists as much as I do, so don't deny it. I love making lists. Make another list of things that you remember from quarantine that you want to bring to normal life. Life. Y'all, there is no normal anymore. There's no times. There's no dates have no meanings anymore. I'm saying that to all these people who are like, I do dates for my life. Like, this is what I do. I just want to encourage you to remember what you told yourself when you had that moment of stillness and that moment of, ooh, my normal has been shattered. When we get back to a new normal, what am I going to want to change? What am I going to want to do differently? Highly recommend you write that down so that you remember, as I was forced to, when things did pick back up and I did the exact thing I said I wasn't going to do, which was fill my schedule. What changes are you going to make? So the biggest thing I want you to leave here today, and again, I wish I could be with you in person. I wish I could just hug on all of you and tell you all that what you do matters and who you are matters. The office of my school through all of my grades was one of the safe places for me growing up. My dad passed away when I was in the 8th grade, and there was a lot, and the office, particularly the secretaries, were my safe space. They didn't even have to say anything. Just knowing that I could walk in and they would say, come on in, and that I was welcome, made all the difference. So what you do matters. The work you do matters. The people that the problems that you solve matter. The fires you put out matter. The phone calls, the emails, they matter. What you do matters. But even more than that, your heart matters. Your joy matters. Your soul and the happiness of your soul matter. So while, yes, you are putting out fires and saving the world and being the backbone of your school, when in the tribute video, which was so beautiful, it made me think of, first of all, y'all have bears on the playground? What? I need to move to Connecticut. That's awesome. That made me laugh out loud when it was in that video. Bears on the playground. You know how in a hospital, they're like, you know who you don't want to upset? The nurses. Yep, you don't want to make the doctors mad either, because that's not good for anyone. But the nurses, you really don't want to upset them. Or in theater, in performing entertainment, the people you really don't want to upset are the technicians. They're the ones who make sure that you're lit on the stage, that you can be heard on the stage, that you have a stage to stand on. They are the ones who you don't want to upset. Our administrative assistants and our secretaries are the ones you don't want to upset them. And like the wealth of secrets and knowledge that you all know, I can't. The things that you all must hear on the daily is awesome. But everything that you do matters. The problems you solve matter. All of it matters. But what matters even more than all of that is your heart and your well-being and your joy and your happiness. We can't give that to you. You have to find that in yourself. I wish that I could come on here and be like, hey, everyone, I have a new chapstick. And all you have to do is apply it. And it has these little like toxin-y things in it. And it's going to make you joyful. That's it. Like it's going to actually put like these like childhood dream things in your lips. And then you're going to speak joy all day long. It's a magical thing. I can't. What I can do is give you the tools to say, hey, your heart matters. And you don't have to fall into bed exhausted and burnt out from giving and giving and giving. You don't have to live that way. Because as much as what you do matters, you matter even more. So please, please find a way to find little moments throughout your day that are for you and only you. Self-care is not selfish. The people around you who might have to be around you when you haven't eaten and you're hangry or you're really tired and then Catherine comes out, they will be grateful because at the end of the day, you are the one that matters. Your heart matters. So find places throughout your day that are specifically for you and no one else. Things that bring you joy. Maybe it's a kind of candy. Maybe it's listening to a certain song. Maybe it's, I don't even know. If you have anything, toss them in the chat. The great thing is there isn't a wrong answer to this. There isn't a wrong answer to this. So that is me. That is what I have for you. I am just so honored to be in your all's presence. Being here with you. If any of you, we have a little bit of time, we have about 15 minutes. If you all have any questions or anything that you would like to ask or share, I'd love to do a question and answer session. I know I just threw a lot at you. So you can, if you have a question, you can toss it in the chat. If not, I can sit here and ramble for another 15 minutes. But it is just such an honor to be here with all of you. I wish I could be there in person. Give you just 1 second to see if there are any questions. If any of you are ever in Florida, please look me up. I would love to meet and say hello. I am based out of Orlando, where I do perform sometimes. Right now, I am more a full-time speaker, so traveling all over, working with your students. But it's good. So, all right. If you don't have any questions, which I'm not seeing any, I know I threw a lot at you. It was a lot, and a lot of really personal stuff. A lot of really personal stuff. So, okay. Well, thank you for. Oh, you're so welcome, Robin. You're so welcome. Being an adult is hard. Adulting is hard, and no one ever really prepares you for that. No one ever really tells you, like, by the way, it's really hard making friends as an adult. That's tough. You all are so welcome. I am so grateful to have been here. Sharice, I can pass it on off to you, or Rosie, I can hand it off to you. You all are wonderful.
Oh, thank you so much, Kate, for being here. And I have to tell you, your words were so inspiring for us this morning. I loved how you started out with talking about what if we took all of our intentions and put it toward loving others, understanding others, and loving ourselves and taking care of ourselves. And the biggest takeaway for me is self-care is not selfish. I think that is probably such an important message for all of us. And I know that you have given us a lot of strategies for how we could be gladiators like you are, or whatever it is that we want to be, so that we learn how to take care of ourselves and our hearts so that we can take care of others. What an inspiring message that you gave us. And if we were in real time in person, I would say, okay, right now we just need to all get up from the tables around the AquaTurf, which is where we would be, and give a big group hug. And we can't do that. So I just want to say that we are all sending you our virtual hugs, and to you and to each other. So thank you so much for inspiring us today and helping us to realize that our hearts matter and that we matter. So again, thank you, Kate, for being here.
You are very welcome.
And now I want to just say that we have another surprise for all of you. So I hope you don't go away yet. And that is that we have a second door prize that has been donated by the Hartford Athletic. We want to thank them for their generosity. Hartford Athletic is Connecticut's professional soccer team competing in the USL Championship United Soccer League. The prize is a family 4-pack of tickets to the Hartford Athletic, a sticker, and a scarf. And again, and this time I turned off the blur so you can actually see, yes, Rosie does have all of your names in a bowl. And I am going to mix them up so that I can pull out one special person's name. And this one for the tickets, the 4 tickets to the Hartford Athletic, a sticker and a scarf, goes to Lisa Ruggles, Brookfield Administrative Assistant Center Elementary School. So congratulations to you, Lisa. You've just won. There you go. A beautiful scarf, 4 tickets to the Hartford Athletic, and a sticker. So again, congratulations to you. And once again, we hope that you have enjoyed the 2022 Virtual CAS Administrative Assistant and School Secretary Conference. I would like to congratulate our 2022 CAS Administrative Assistant of the Year, June Rydzik. We want to thank Tom Mooney and Gwen Zittoun for a very informative presentation and Q&A to help us navigate the ever-changing legal landscape, and Kate Garnes for her uplifting and motivational words, reminding us that even when everything feels lonely, we're not alone. So thank you to everyone this morning, Tom, Gwen, and Kate for being here. And again, congratulations, June. We'd also like to gratefully acknowledge our wonderful corporate partners, Pullman and Cumley, Connecticut Army National Guard, Connecticut Department of Public Health, Connecticut Alliance to End Sexual Violence, Connecticut Department of Transportation, Connecticut Lighting, Johnston's, Horace Mann, and MCM Fundraising for helping us make this webinar possible. We thank them for their continuing support of our professional learning opportunities for principals and educators in Connecticut. Again, we're dropping the link to our brief conference evaluation survey into the chat. We greatly appreciate your feedback and thank you in advance for completing the survey before you leave the conference today, or as soon as you click off the conference, please fill out the survey so that we have your feedback. And once again, from all of us at CAS, a huge thank you to all of our administrative assistants and secretaries for everything you do each day to make our schools safe and welcoming for everyone in our school community. We couldn't do it without you. You are appreciated, you are loved, and you truly make a difference. So thank you, thank you, thank you. And now it's my pleasure to once again turn this program back to Matt Scott at Fox 61 News for your final thoughts and closing remarks. Take it away, Scott.
And that's going to just about do it for the 2022 CAS Virtual Administrative Assistant and School Secretaries Conference. In closing, we'd like to once again recognize and thank all of our dedicated, caring, and amazing administrative assistants and secretaries for everything you do every day to make a difference for your school communities, especially the administration, teachers, staff, and most of all, our students and their families. We couldn't do it without all of you. Thank you all, and keep up the good work.